other application for the extension of time, it should also be before the ordinary bench.
Yeah.
So that was why we decided that we can take. The lead counsel is now in. Yes.
Well,
you can take a review.
So Mr. Chikata will take the review.
My Lord, respectfully, we have an application for review before your lordships.
Time management, you have 30 minutes.
Very well.
And there'll be no extension of time.
I'm sorry, I didn't hear that.
There'll be no extension of time.
The application for review is brought under Article 133(1) of the Constitution and Rule 56 of the Supreme Court rules. I respectfully move in terms of the motion paper and the supporting affidavit. And this review is in respect of our application to reopen our case. And your lordship's ruling is our first exhibit attached to the application. And in our respectful submission, as our ground indicates, this ruling was per incuriam section 72 of the Evidence Act 1975 and has occasioned a grave miscarriage of justice. There's no question that in your lordship's ruling there is no reference whatsoever to section 72 of the Evidence Act. Instead, there's a reference to Black's Law Dictionary, which is an English law text. No reference is made to section 72 of the Evidence Act. Section 72 of the Evidence Act is a statute of Ghana. No reference is made to that, and instead there is a reference made to an English law textbook, which is not what is binding on your lordships. That is why we say respectfully that that decision was per incuriam section 72 of the Evidence Act. And my lords, the authorities are clear, and we have cited Republic against Tete, which is 2003-2004, Supreme Court of Ghana Law Reports 140, where their lordships in the Supreme Court reversed a unanimous decision that they themselves had given, and they reversed that decision on the basis that they had failed to take into account the Armed Forces regulations, which were part of what their duty was as a court of Ghana. They had failed to take it. Account. They had failed to take And so their lordships in Republic against Tete reversed a unanimous decision that they had taken, and they unanimously corrected an error. Now, my lords, in an another ruling your lordships have given in this case recently, your lordships have said that even if you did not refer to a certain statute in your judgment, we have not shown that it occasioned a miscarriage of justice. My lords, respectfully, that is fundamental error. Republic and Tete shows that one at any time during the presentation of our application, of our grounds. Ground B says that the ruling was in fundamental error in subjecting statutory provisions in the Evidence Act to the provisions of subsidiary legislation. My lords, there again, nothing could be more basic. Nothing could be more basic than the fact that a statute is superior to subsidiary legislation. The Rules of Court Committee are not of in ground D. So we dealt with A, B, and C. We indicate in ground D. We take B and C together. And I argued in relation to B and C that the fundamental errors consist of sidelining legislation in favor of subsidiary legislation, and in relation to ground C, sidelining it in favor of subsidiary legislation which is irrelevant to the issue in the statute anyway. And so we move to ground D. And in ground D, our submission is that, here again, the court made no reference whatsoever to Order 38, Rule 10 of CI 47, nor indeed Section 58 of the Courts Act. And Section 58 of the Courts Act is a section which even gives power to your lordships to call a witness. And that section has been properly applied. So in other words, apart from our ability to subpoena upon reopening of our case, apart from that, there is also the opportunity for this court itself to call a witness. And the circumstances in which the court does that, those circumstances are exemplified in the case of Wadier and Bukhari. Wadier and Bukhari, 1976, 2 Ghana Law Reports, 371, where the Court of Appeal, the then Apex Court, proceeded as follows. And this is from the judgment of Justice of Appeal Archer, as he then was. After judgment had been reserved in this court, it was felt that this court should not be placed in the same situation in which the court below found itself. It was therefore decided to ascertain the truth in this matter, and so on. And based on that, the court had recourse to the Courts Act to ascertain the truth of the matter. And then the court went on to point out that just that invitation of the witness to come and testify had brought up a very important piece of evidence which, if it had been adduced in the court below, would have spared that court the torment of exploring whether or not the certified true copy of the plan from the Lands Department was the plan tendered before Jackson J. And the court even goes on to say one can understand Mr. Joe Randolph's initial reservations, but as this additional evidence has enabled this court to ascertain the truth beyond all doubt, we think by allowing this additional evidence to be admitted, Mr. Randolph conducted himself in the best traditions of the bar. Indeed, those words in respect of the best traditions of the bar evoke some nostalgia in the hearts of some of us. And my lords, we are respectfully saying that the ruling that your lordships gave did not even advert to Order 38, Rule 10, which we had indicated was the basis on which we were seeking to reopen our case. He didn't even advert to that, and it was therefore per incuriam. We say also in ground E, which I move on to now, that the ruling was per incuriam Article 1913 of the Constitution and has occasioned a grave miscarriage of justice. And Article 1913 is the provisions on the right to a fair trial in this court. And we show in our submissions on that matter how this Supreme Court adverted its mind to a decision of the Supreme Court of the Netherlands, in which the Supreme Court of the Netherlands was highlighting the importance of ascertaining the truth in matters that were before it. And that was made to displace, in the interest of the right to a fair trial, it was made to displace even international relationships as being something that the court would have reference to. That decision in the case of Chachuchigata and the Republic is a decision that we have cited in our submissions, and I will not go further into that except to underline the fact that the Supreme Court of the Netherlands, whose reasoning was adopted by the Supreme Court of Ghana, also considered it appropriate that in the interest of ascertaining the truth, it was of value to the court to call a witness.
Once again, I'm curious about something. If it was so important to you to have a particular person testify for you, why did you not present that as part of your pretrial positions?
My lords, we could not, for the reason that I've given a few times in this court. At the time, that first respondent's chairperson was the person who had filed a witness statement on behalf of, well, first of all, had filed an affidavit of verification of the case of the first respondent. Subsequently filed a witness statement on behalf of the first respondent. And my lords, the earliest...
So, in essence, you were hoping to rely on her coming to testify and found yourself without that. And that is why now you are asking that she comes as your witness after everyone has closed their case.
My lords...
Is that what you're saying in essence?
My lords, what we're asking is for our case, for us to have leave to reopen our case. That witness, as we've indicated, had sworn affidavits in response to our application for interrogatories, in response to our application for state relation to that. And in those, she had given every indication that she would testify. We had no reason to believe that she wasn't telling the truth. We had no reason to believe that she didn't mean it when she swore those affidavits. We had no reason to believe that anybody in the court would have assumed other than that she would testify. In fact, the day that it was announced that she would not testify, on that day, your Lordship themselves expressed, some surprise. And that was the reason why you adjourned to the next day for arguments to be raised and so on. So, my lords,
when you announced that you had closed your case, what did you mean?
Nothing more, nothing less. We had closed our case. And when we announced that we are seeking to reopen our case, I mean exactly that, nothing more, nothing less. We are seeking leave to reopen our case in circumstances where a person who has deposed to affidavit saying she will be available for cross-examination, and where your ladyship specifically had intimated that the questions that we're seeking to raise in interrogatories could be asked of her in cross-examination. I'm sure your ladyship has not forgotten that bridge. And in that context, your ladyship had said that aren't we crossing a bridge that we have not got to? And we indicated that at the stage of interrogatories, we still found it appropriate to anticipate that. But your ladyship said the bridge will be there. That bridge is no longer there.
When you said that you closed your case and you meant it, nothing more, nothing less, what did you mean?
I really don't understand what more your ladyship wants by way of an answer. We meant that we had closed our case. And we had closed our case, and subsequently we sought leave to reopen our case. Your ladyship cannot say that we are not able, under the rules, under your inherent jurisdiction, to ask for your leave to reopen your case. I don't believe that that is a suggestion that your ladyship is making.
I don't think I've said any such thing. So
but it just is very difficult to comprehend.
I just wanted to understand what you meant when you said you have
I've answered that question, I think, twice or
nothing more,
already.
nothing less. And I'm certain satisfied with the answer, sir.
My lords, we continue finally to the last ground. That the ruling was in breach of Article 296. And very simply put, what we're saying is that that ruling is completely unreasonable in terms of what are often referred to as the Wednesbury principles. And her ladyship by the TDC defies logic and common sense or accepted moral standards, which prejudiced a fair exercise of discretion as required by Article 296 of the Constitution. It is our submission that holding the first respondent, and particularly his chairperson, accountable for the exercise of powers conferred by the Constitution and statute justify, in the circumstances of this case, that that chairperson be called upon to testify using the time-tested subpoena procedure that we seek to invoke in this case. My lords, there is no question that the process of review is among the ways in which corrections are made by your lordships, and as Aqua,
Your time is up.
may I just finish in a minute because I'm in the middle of a sentence? Is that allowed?
Okay.
As,
You may finish.
as Aqua indicated in the Koblex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated on oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind, and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear.
Order in court, please. Order.
Yes. My lords, we are vehemently opposed to this application for review number 3. Lord, we have filed an affidavit in opposition as well as a statement of peace, and we rely on it. Lords, under Article 33(1) of the Constitution, this court may review 133(1) of the Constitution. This court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of court. Also, even the Constitution recognizes the role that is played by the Rules of Court Committee. And indeed, my lords, the Rules of Court Committee passed the Supreme Court Rules 1996 CI 16. And lords, the specific rule on review is Rule 54. Lords, this court is the final court of the land. We concede that the court is not infallible. But, my lord, your lordships may change your mind in an application for review only when certain conditionalities have been met. Lords, those conditionalities have been set out in utter number 2 versus Arthur number 2, 2013-2014. One Supreme Court of Ghana Law Report 569 at page 579 to 580. Because I will not read those conditionalities, but they are there. Lord, it's only when those conditionalities have been met that the review panel should seriously consider the merits of the application. Lord's submission that the conditionalities set in Rule 54 of CI 16 and Attentive Panel of 7. Indeed, if we want to give some credit to the grounds, my lords, they are at best additional grounds that have been filed without leave of your court in terms of an appeal, but they do not form grounds for review for which my lords should proceedings to permit new or additional evidence. Then your lordship conclude that in this application of any attack or any submissions regarding this application must fail. It still doesn't have the inkling of the evidence that the applicant A, and by agreement of counsel, the court then said that let an expert come and testify as to the authenticity of the document. So in that case, the court allowed further evidence just because the evidence that the expert was being called was known. This is not the situation in this case. Lord, what has been done is that there has been arguments that border on the nature of an appeal. Indeed, my lords, look at paragraph 3 of the affidavit in support. With your kind permission, if I may read. He says that at the hearing of this application, I shall, through my counsel, seek leave of this honorable court to refer to all processes filed in this case up to the date of the hearing of this application, clearly indicating to your lordships that he is going to argue an appeal. And that is why your lordships yes.
You see, so in motions,
yes.
What you try to do is that instead of seeking leave when you are on your feet, to refer to it,
yes.
You can come it in the affidavit.
Yes.
So the
in court proceedings.
Mr. Menuvo,
Yes, sir.
are you referring to me as a sore loser? I argued that application for review before this court. I was standing where you were some few years ago, and I lost that application.
Well, my lords, the review panel forms that view of you. The review panel forms that view of you, my lord, and indeed of your client, my lords. My lords, incidentally, my learned friend was on the other side in that matter, and he got the review. Yes. My lords, the case of Mechanical Lloyd Limited versus Nati again is there on the point. Lord's arguments have been made in this court regarding fair trial. My lords, I ask just a couple of questions of the this petition, my lords, has been conducted in a piecemeal fashion, which is one of the things that CI 99 deprecates. First, orders of the court are disobeyed. File, witness statement, no. You yourself intimate that I'm going to call 5 witnesses. You call 2. And then you come back to the court, oh, my lord, I forgot one person, permit me. It is permitted. You call that person. Yes, my lord. Oh, my lords, this is the issue of fair trial. My lords, with the greatest respect, the issue of fair trial has been raised. And now I'm saying that he has been given fair trial in the way the case has been conducted, my lord. Lord, then we go from there to having called the 3rd witness. What is your pleasure? Oh, my lords, I close my case of your own volition. Lord, it is my submission, therefore, that the petitioner was given every opportunity. He was fairly heard in these proceedings. And what has been filed, review number 3, is an abuse of the court processes, and the application ought to be dismissed in limine.
Mr. Menuvo, you have not addressed us on the reference to Hosea, the gospel according to Hosea. Yeah.
My lords, I made
Order, please.
My lords, my point I wish to make on that, if you permit me, is that God is a God of conscience, and God does not use court processes to elicit conscience. No. God is a cause of conscience, and therefore you do not bring God into the courtroom to now claim that because of God, application should be granted. That's my response.
Isakutampa.
30 minutes.
My lords, we are opposed to this application, and my lords, we rely upon affidavits in opposition filed on the 21st of February, together with our statement of case. My lords, our first submission is that this application woefully fails to satisfy the conditions for the grant of a review application. As in our view, it does not demonstrate any fundamental error committed by the court which has occasioned the petitioner a miscarriage of justice. And on that ground alone, this application ought to be dismissed summarily. My lords, now on ground A of petitioner's application, the petitioner refers to section 72 of the Evidence Act. Now, my lord, section 72 of the Evidence Act reads thus. 72 sub 1. Subject to the discretion of the court, in a civil action, a party or person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence. At any time, my lords, during the presentation of evidence by the party calling the witness. My lord, it is very significant that in his statement of case, there is a deliberate omission of the controlling word evidence by the party of evidence. That is, and I see no reason to believe that this was inadvertent, because it is repeated twice. And on both occasions, this critical word is left out of evidence. Now, what is the significance of adding of evidence, reading section 72(1), including of evidence? It means that a party can only exercise that right when he has not closed his case. That's what it means. And I want to repeat this. Section 72, which appears to ground the backbone of this application, relates to a situation where a party has not closed its case. Now, in this instant situation, the party had closed its case. So the court had no business referring to section 72(1), because it was irrelevant to the circumstances of the case. And my lords, it is my submission that knowing that they had closed their case, the petitioner disingenuously omitted of evidence. And with all due respect, this is highly improper. So, my lords, all the submissions around section 72 that the court was per incuriam of section 72 are totally unmeritorious and irrelevant. Now, my lords, we proceed to deal with grounds B and C. And my lords, counsel for petitioner has argued that Order 38, Rule 3E, 5 cannot override Section 26 of the Evidence Act, because in his view, the Evidence Act is a substantive legislation, and Order 36 is subsidiary. My lords, 38, sorry, is subsidiary. My lords, it may well be the case that Order 38, Rule 3E5 is a subsidiary legislation. But the point here, the critical point here, is that the very principal act, this is the Evidence Act, Section 26, by itself delimits the application of the main text by the words subject to a rule of law or equity. And my lords, there can be absolutely no doubt that Order 38, Rule 3.5 is part of the laws of Ghana. So it is because of the specific provisions of Section 26 that the court could then look at Order 38, Rule 3E5 and rely upon it in making its ruling. So, my lords, respectfully, I think it is misconceived to suggest that in doing so, the court had committed a fundamental error by allowing a subsidiary legislation to trump a substantive act of Parliament. My lords, we would next address Rule Ground C, which relates to Act 459, Section 58. Ground D. My lords, in my respectful view, Section 58 of Act 459 is completely irrelevant to the matters before the court. Because the matters before this court, which is the subject matter of the review application, relate to the court's decision not to reopen a case. My Lord, that is the decision of the court. Now, Section 58 reads, in any proceedings and at any stage of the proceedings, a court, either on its own motion or on the application of any party, may summon any person to attend to give evidence or to produce any other document. My Lord, this provision presupposes that the party who is applying to summon another has not closed his case. Now, this is obvious common sense. It is very clear that this provision cannot relate to a situation where a party has closed his case. And my Lord, these are the ways in which provisions of the law have been persistently cited out of context. Perhaps to mislead those who do not know the law. So, my Lord, it is our respectful submission that a reference to Section 58 of the Evidence Act, of the Courts Act, in this situation is totally misconceived. and should never have been made by counsel. My Lord, we wish also to make the point here, for the last time, that the chair of the first respondent has never made any undertaking that she would mount the witness box, such that the petitioner could claim that he relied on it to his detriment. My lords, all that the chair of the first respondent did was to repeat what the law is. That is all that he did. The law, and if your lordships go to order 22, rule order 22, all that the chair of the first respondent did was to repeat the position of the law, which is that if you fail to obtain interrogatories in relation to a matter, you may, during cross-examination, elicit the same information. That is all. It was never an undertaking. And it beggars belief that the petitioner and counsel are basing this statement of the law as an affidavit, an admission or a representation that they relied upon to their detriment. My Lord, I therefore wish to submit that a reference to the deposition of the first respondent's chair on this matter can never constitute an estoppel, because she has the right to refuse not to enter the witness box. And the court has ruled definitively on this. This application for review of the decision to reopen cannot be the back door through which that earlier ruling can be considered. The court has ruled on it, and that ruling binds all of us, including counsel for the petitioner. My Lords, the fair hearing argument, my Lords.
There are 5 minutes more.
Very well.
No, 10 minutes.
My Lord, I thought I had a lot more minutes. Unless your Lordship thinks I've made out my case, so...
You have 5. Out of the 30, you have 5 minutes more. Thank you.
My Lord, ground E relates to the allegation of breach of his right to fair hearing. My Lord, the right to fair hearing is a right that all parties to a suit are entitled to. So, the court has ruled that the respondents have the right to elect not to adduce evidence. That is their right under the law. Therefore, to seek to reopen your case so that you can compel the first respondent through his chair to enter the box. It's a breach of the first respondent's right to fair hearing also. My Lord, with our considered view that no evidence or analysis has been made by counsel for petitioner that sustains their claim that their right to fair hearing has been breached. Indeed, this court has been more than accommodating to the first, the petitioner. They defied the court's order with impunity not to file witness statements at the time they were ordered to. They have even again defied the court's order to file closing addresses. And perhaps the court may once again accommodate their defiance of the highest court of this land. And then they turn around to talk about fair hearing. In our respectful view, their case should have been struck out when they failed to file their witness statements as ordered by the court. Or it could have been struck out. And as we speak now, since they have defied once more to file their closing address, this case can be settled without their closing address, and it will be fair trial. My Lord, I'm saying it will be fair trial for that to happen. Possibly the court is once again going to accommodate them. So they should be the last people to be mounting the high horse and talking about breach of their right to fair trial. My Lord, our respectful submission is that this allegation of breach of their right to fair trial is an invitation to the court to go on a frolic which has absolutely nothing to do with the issues before this honorable court as to whether any person, any of the two parties, the petitioner or the second respondent, obtain more than 50% of the valid votes cast in the 2020 elections, presidential elections. My Lord, again, the reference to 296 is in our view quite surprising. Yes, my lords, the court was right in the TDC case to hold that the acts complained of were unreasonable and irrational. But my lords, in the instant application before your lordships, the petitioner has failed once again very badly to demonstrate the facts which ground the allegations of unreasonableness or irrationality. Because those facts, my lord, are based on the grounds that he has dealt with earlier on, A, B, C, D, which we have demonstrated to be hollow and of no merit. Accordingly, my lords, we believe that, and we submit that the application is devoid of merit. It is deserving of a summary dismissal, and given the fact that the arguments are only a rehash of earlier arguments and the introduction of irrelevant provisions for the consideration of this court, we pray that in this exceptional situation, this application be dismissed as an abuse of process. It be dismissed as an abuse of process and cause punitive costs.
Your time is up.
Malted. My Lord, we are done.
My Lord, may I, with your leave, make a couple of brief references. My learned friend for the second respondent, I heard him a little while ago say that we are acting in breach of the right of the chairperson of the first respondent as far as testifying is concerned, as far as our indication that we are seeking to subpoena is concerned. And my Lord, that's a matter of law, respectfully. It is not for the second respondent to bring up a witness's claim to immunity, whether on the basis of a right to fair hearing or self-incrimination or whatever. It is not for the counsel for the second respondent to bring up a witness's claim to immunity. The witness must themselves, that witness must, his or herself, I should say, his or herself, put forward whatever claim she seeks to make to immunity. And my Lord, I believe that that was the reason for our reference to the case concerning the IFC's immunity and so on. And my Lord, counsel for the second respondent also sought to suggest that I had somehow sought to mislead the court in terms of section 72. Well, that's a very serious insinuation. Well, it's not actually an insinuation. It was a very express statement on his part. And my Lord, I can only say that counsel is obviously not clear about the nature of the application that is before you. Because the nature of the application that is before your lordships is to seek to reopen our case for the presentation of evidence. That's the nature of the application that is before you. So, reading section 72 about the presentation of evidence and making it seem as if what we are doing is somehow foreclosed because we have closed our case just shows that he hasn't understood why we are in court this morning. Because, my lords, we are in court asking your lordships to reopen our case so that we can go according to certain processes. That's what we are in court for. So for him to be saying that we are trying to mislead you by not referring to during the presentation of our case and so on, my lord, that is just a clear failure to appreciate the terms of section 72. And my lord, he completely does not address the point that we make, that section 72 was not even referred to by your lordships, and that your lordships ruling is per incurium of that section.
Are you done?
Yes, I'm done.
Yes. I have one question for you.
Yes.
Your arguments, you dwell mostly on section 26. Section 26 of the Evidence Act. Can you show me any conflict between section 26 and order 38? Is there any conflict between section 26 and order 38? 38, rule 3, E5. Is there any conflict?
My lords, I was referring to the fact that the ruling implies that there's a conflict, and that in the ruling it says this section is not applicable because of order 38.3e. And my lords will notice that I in fact went on to argue. I argued that rule 38.3e5 in fact has nothing to do with section 26. Your lordship will recall that I argued that. So I was specifically referring to what was in the ruling. The terms of the ruling are clear.
So it was not a matter of the court preferring subsidiary legislation to a substantive
That's what the court said. I mean, I read it. The court said.
No, we didn't say so.
We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38.
But it doesn't mean that the court was preferring or raising Order 38, raising 38 against above Section 26. That is not what we meant.
Well, my lords, I leave that to your lordships, but the language of the ruling is what I'm referring to. But I leave it entirely to your lordships. The language is that it is not applicable in view of something else. So that other thing is being made applicable, whereas Section 26 is not being made applicable. I mean, there's no running away from that. If you say this is not applicable in view of this, then it means that what is you say is applicable.
Yeah. No.
You're setting aside.
That is what I'm not. It doesn't make it superior to Section 26.
Yeah, but my lord, how can your lordship say that Section 26 is not applicable in view of Order 38?
That is our view.
Yes, but my lords, and that was the other point I was going to make, respectfully, and I'm glad that it has come up. Reference has been made to your ruling in respect of another application in which you did seek to consider Section 26. And there we argued that no reference had been made. It was per incuriam Section 26. In that ruling, again, no reference was made to Section 26 at all. In your ruling in that case, your lordship said, effectively, yes, we didn't make reference to that Section 26, but we haven't been shown that a miscarriage of justice has arisen because we didn't make reference to it. And my respectful submission is that, and I did say so, that is itself fundamental error. And your lordship should take the opportunity to correct that error, because you didn't make reference to Section 26, and you sought to justify that by saying that no miscarriage of justice has been shown to you. And my submission was that when you don't apply a statute, there is no reason for miscarriage of justice to be a further ground.
Different from,
I'm sorry.
When you don't make a reference, it's different from not applying.
Well, my lord, if you don't even make a reference, you can't apply. I mean, if you don't even make a reference to it, you can't apply it. I mean, you make a reference to Black's Law Dictionary. Black's Law Dictionary, you make a reference to that. Black's Law Dictionary is not binding on this court. It's stating common law rules which have been changed by statute in this court. But you make reference to Black's Law Dictionary. But you don't make reference to the statute that is binding on you. Well, that is per incuriam. That's
No. That is your opinion.
Well, that is indeed my opinion, and I think it's backed by a plethora of authorities of this court.
The court will rise to consider his ruling.
All rise.
and principalities.
There's so much fire inside me.
Tragedy struck when part of the largest hillside at the kosher rubbish dump collapsed.
It's going to be fun to see how he goes about approaching this game.
Powers and principalities.
There's so much fire inside me.
Tragedy struck when part of the largest hillside at the kosher rubbish dump collapsed.
It's going to be fun to see how he goes about approaching this game.
powers and principalities.
There's so much fire.
Back to our studios here at the GTV Broadcasting House here in Kanda. You just heard the arguments coming from the petitioner and from the first and second respondent. The petitioner arguing why a review should be given to that ruling on the 16th of February, which the courts said that they will not allow the petitioner to reopen their case. So the petitioner this time around had to argue out a review of that particular judgment. The first and second respondent argued against that particular review. As of now, the court moved into its chambers to decide on whether to grant that kind of review or not to grant that review. And realize that because it's a review application, you had 9 justices sitting to determine the review, unlike the 7 for the main case itself.
Right. And also, Judge, today, I mean, if the plans of the courts, you know, go through, then we are expecting to hear the date for the final ruling. That's if nothing changes. That's the indication we have. But let me just take our viewers through the grounds upon which the petitioner is seeking a review of the 16th February ruling. And the first ground is that the ruling of the court was per inquirium, Section 75 of the Evidence Act 1975, NRCD 323, and has occasioned a grave miscarriage of justice to the applicant. And so we have Dr. Budu, who is on the standby. You give us an understanding of some of these constitutional provisions and what they mean. The second ground is that the ruling of the court was in fundamental error in subjecting statutory provisions in the Evidence Act 1975 of the provisions of subsidiary legislation, specifically Order 38 Rule 3A5 of CI 47 as amended by CI 87, and has occasioned a grave miscarriage of justice to the applicant. The ground C says that the court fundamentally erred in its interpretation of Order 38 Rule 3E5 of CI 47 as amended by CI 87. D, the ruling of the court was per inquirium, Order 38 Rule E of CI 47 and Section 58 of the Court Act 1993. Let me do E. The ruling of the court was per inquirium, Article 19(3) of the Constitution, and has occasioned a grave miscarriage of justice to the applicant.
All right, so we have Dr. Kwekwajiman Budu, who is a lawyer, is a law lecturer, the head of Law Center's Gimba Faculty of Law, and also the founder and executive director of the Justice Foundation. Doc, we're back. Good morning once again, and just take us through some of the presentations, I mean, from the 3 sides, then we can move into other areas too.
Oh, okay. So basically, as you rightly summarized, this morning's proceedings have been in relation to an application that was brought by the petitioner, basically seeking the court to review its decision or its ruling that it gave on 16th February in relation to the application to reopen their case. You remember that the petitioner had closed its case and the respondent also closed their case, and we saw an objection which was in relation to the earlier ruling which we talked about earlier on, the fact that the respondents had closed their case, but afterwards, the petitioner also filed an application seeking to reopen their own case, to issue a subpoena to compel the Electoral Commission chairperson to testify, and that application was not granted, and so that is the basis for this review application today. So as you rightly pointed out, the petitioner is seeking a review of that ruling of 16 February on 6 main grounds. And earlier on, before we went for the proceedings, you were asking, I think Morris was asking about Article 133 and Rule 56. Sure. And Article 133 of the Constitution, yes, basically provides the review jurisdiction of the Supreme Court and gives them the power to review any decision that they have made or given on such grounds and on such conditions as the Rules of Court Committee will prescribe. And the Rules of Court Committee is that committee under the Constitution that has been given the mandate to prescribe rules of procedure that must be followed in our various courts. And they exercise that power to enact, if you may, the Supreme Court Rules of 1996, CI 16, which provides for 2 grounds of review in Rule 54. The first ground, which is what the petitioner is coming under, is that there are exceptional circumstances which have resulted or occasioned the miscarriage of justice. The second ground that a petitioner can come on for a review is that they had discovered or have discovered new and important matter or evidence which, after the exercise of due diligence, was not within their knowledge or could not have been produced by him during the time the earlier decision was given. So that's Rule 54. But Rule 56, which the applicants base the application on, which I believe that's why you were asking, is a rule that provides for the procedure and requirements that you must comply with when you're bringing an application for review. So basically, it has to be by a motion which is supported by an affidavit and accompanied by a statement of the applicant's case, which will clearly set out and fully argue all the relevant grounds on which the applicant is relying for the purposes of the application. So that is why we see Rule 56 being cited by the applicant, because they are complying with that particular rule in the sense that they filed a motion for the review that was accompanied by an affidavit deposed to by the petitioner, and also they had a statement of case in which they argued those 6 grounds which you talked about, which you set out for our viewers, which relates to exceptional circumstances occasioning a miscarriage of justice. So that is basically the preliminary points in this whole discussion.
All right, so one of the so the petitioner says that the Supreme Court didn't make reference to Section 72 of the Evidence Act, and you realize that both the petitioner and the first respondent counsel have in a way read that same section to us in different forms. Can you just take us through Section 72 and help us understand some interpretation from the academic point?
So basically, that is the ground, the first ground for review of the applicant's petitioner. So that ground, as you rightly stated, was that the ruling of 16 February was per incurium. Per incurium meaning the ruling did not have due regard or did not have regard for Section 72 of the Evidence Act, and as a result occasioned a miscarriage of justice, on the petitioner. So what does Section 72 say? I wanted to project Section 72 so viewers will be able to follow through, but I don't think screen sharing has been enabled. So if subsequently it can be enabled, it will make it much clearer as we go through the discussion.
Right.
But basically, Section 72 provides, and permits me to read slowly so that we follow.
Sure.
It provides that subject to the discretion of the courts, in a civil action, a party or a person whose relationship to a party makes the interest of that person substantially the same as a party may be called by an adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. So that's what Section 72 says.
Sure.
And the petitioner is therefore arguing that by virtue of the fact that the court in its ruling on 16 February only referenced the Black's Law Dictionary's definition of adverse or hostile witness without adverting its mind to Section 72 of the Evidence Act. To that extent, the petitioner believes that the court erred because, according to the petitioner, the law of Ghana on adverse witnesses is provided for by that provision, that is Section 72 of NRCD 323, and not the Black's Law Dictionary, which is not applicable in Ghana, which basically only states the common law position, which, according to the petitioner, is not that which is controlling in Ghana by virtue of Section 72. Which means we need to remind ourselves what the court actually said in that ruling in relation to that particular issue of adverse witness. And this is what the court said. And once again, you permit me to read it out so that we set it out in context.
Sure.
The court said in part that, and I asked this question to begin with, does the petition need the personal testimony of the chairperson of the institution sued before he could prove or establish the alleged non-performance of this constitutional duty by the first respondent? We do not think so. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of the first respondent as an adverse witness. Black's Law Dictionary, 9th edition, edited by Brian A. Garner, defined a hostile witness as, quote, a witness who is biased against the examining party, who is unwilling to testify, or who is identified with an adverse party, also termed adverse witness, end quote. A hostile or adverse witness, as the definition shows, and as we understand the term in practice, is therefore a witness who has been called by a party to testify in support of his or her case, and who, whilst in the witness box and the examination in chief, becomes hostile and gives evidence contrary to the party who called him and in support of his opponent's case. The party, in such circumstances, can apply to the court to treat such a witness who is already in the witness box as a hostile or adverse witness.
Right.
This would enable the party calling him to cross-examine him as if he is a witness of his opponent to solicit the truth in respect of the issue at stake. A witness who has not yet entered the witness box to testify cannot therefore be called an adverse or hostile witness under any circumstances.
Right.
And that was the ruling of the court in relation to that particular issue. So the first point that we need to understand is that the Evidence Act, the NRCD 323, captions Section 72, which I read out earlier. It captions it as follows, that adverse witness in a civil action.
Okay.
But if you read the provision carefully, it does not necessarily define an adverse witness. What it rather does is to give the court the discretion, which simply means discretion means that the court has the power to decide one way or the other. So it's not automatic that the court has to decide one way. The court exercises a discretion to either decide one way or the other. So it gives the court that power to decide one way or the other, whether to enable a party in a civil suit, say a plaintiff, to call another party in that suit, say the defendant, or the plaintiff is also given the power, for instance, to call a person whose interest may be the same as say the defendant, at any time during the presentation of evidence by the party calling that witness, that is the plaintiff, who, when they are producing their evidence, they are giving their evidence, calling their witnesses, they have that option to call the other party or a witness whose interest may be in line with that other party so that they cross-examine him. But this is subject to the discretion of the court. And
right.
so it's not automatic. So such persons, for instance, may include persons whose testimony may be in favor of that other party. So for instance, your adversary. So it could be a spouse. So if you are seeking to call the spouse of the person that you have sued, it's sometimes assumed or presumed that the spouse of the parties, his interest or her interest may be in line with that other party, so he or she may not necessarily be favorable to you. That's why sometimes they are referred to as unfavorable witness or hostile witness and things of that sort. So the petitioner is basically saying that the court, in not adverting its mind to Section 72 of the Evidence Decree, or the Evidence Act as it's now referred to, but rather relied on the Black's Law definition of adverse witness, had committed a fundamental error of law, and as a result, a grave miscarriage of justice had been occasioned by the court. That is the argument of the petitioner in relation to the first ground.
All right, so counsel for the first respondent has argued that the Section 72 is applicable only at the presentation of evidence stage. So at that point where the petitioner was seeking to reopen their case, and can we say that they were, it amounted to presenting fresh evidence, and so they were still at the presentation of evidence stage?
So at this stage, what we know for certain is that all parties in this suit have closed their case, their respective cases. And what the petitioner is now seeking to do is to reopen his case. And in reopening his case, all that the petitioner is seeking to do is to introduce new evidence. That is a fact. The court said that in its last ruling, the ruling that is being, that the application is in relation to seeking the review. The court stated clearly that the grounds or the circumstances that the court will consider when exercising its discretion to allow a party who has closed his case to reopen his case are similar or are essentially the same as those circumstances that the court will have to consider when a party seeks to lead fresh evidence. Because essentially, if you are granted that opportunity to or leave to reopen your case, you will be seeking to lead evidence. And the petitioner has not made this, or has made this clear, that the purpose for seeking to reopen their case is to subpoena the chairperson of the Electoral Commission to testify, and there will be evidence in that regard. So he's seeking to lead evidence in that regard. But as of now, their case is closed. So they're only seeking to reopen it to lead evidence. And the respondent is saying that on the basis, or the second respondent at least, is saying that on the basis of the provisions of Section 72, that's why I was saying that if your technicians could grant me access to share the screen, I could be able to share the provision so that viewers are able to actually follow it.
All right.
Yes, because when we're saying it, sometimes it goes a little fast. So if they see it, they'll be able to appreciate it. So Section 72 is saying first and foremost that that provision which allows a party to call another party or a person whose interest may be adverse to the person calling that other person to be treated as an adverse witness, that provision is subject first and foremost to the discretion of the court, which means it is not automatic. So that's the first thing.
Right.
The second thing, which what the respondent is saying, is that if you read the provision carefully, it also says that this can apply at any time, those are the last words of the provision, can only apply at any time during the presentation of evidence by the party called. And the time that you are presenting your evidence is when you are making your case, is when you have, at the beginning, when you are called upon, the plaintiff in a civil suit, for instance, generally will make his or her case first. So when you are making your case, the respondent is saying that it is at that time that this provision can apply, subject to the discretion of the court, because it says at any time during the presentation of evidence by the party calling that witness.
Look, I mean, let's...
And the...
Yeah.
All right, so... Okay, so because we've been talking about the Black's Law Dictionary, I just want to understand the place of the Black's Law Dictionary in our jurisprudence. I mean, you are a law lecturer, and what weight it carries. Also because the counsel for the petitioner disagrees with the Black's Law's definition of an adverse witness, which says that an adverse witness is, you can only call someone an adverse witness when he or she is in the witness box. So I just want to know what place, I mean the weight that the Black's Law Dictionary carry in all this.
So we have the laws of Ghana, and I think in the second or third grounds, I'll come to that to explain what the laws of Ghana are and the hierarchy of the laws of Ghana and all that, so we'll be clear at that point. But basically, the Black's Law Dictionary is a dictionary which gives lots of elucidation in terms of the law generally, and it's one of the seminal publications, if you may, that deals basically most of the time with English law, but we usually make reference to it in Ghana because of our colonial heritage, because of the fact that the common law is that which we inherited and all that. So it is authoritative in the sense that it provides meanings to lots of the legal phrases, terms, and all that. But in terms of the laws of Ghana, the Black's Law Dictionary may not necessarily be considered as part of the laws of Ghana. And that is what the petitioner is essentially arguing, that to the extent that, according to the petitioner, there is a statutory provision in the Evidence Act which deals with adverse witnesses and what an adverse witness generally is and the circumstances under which a party or a person may be deemed an adverse witness. To that extent, the court not adverting its mind to that and only citing or quoting the Black's Law Dictionary, then the court had acted per incurium, because the laws of Ghana include the Evidence Act, but do not necessarily include the Black's Law Dictionary definition on anything. That's why he was saying that, and we heard it towards the tail end, that the Black's Law Dictionary's definition of adverse witness simply captures the common law position, which has been, according to the petitioner, modified in Ghana by virtue of the Evidence Act, Section 72.
All right, Doc, we'll explore further with Section 72 and the Black Law Dictionary based on the ruling. Well, we'll go for a quick break. Just hold on for us. We'll go for a quick break. We're talking to Dr. Kwekwajiman Budu, who is a lawyer, is a law lecturer, head of Law Center's Gimpa Faculty of Law, and he's also the founder and executive director for the Justice Foundation. Stay with us. We're going for a quick break. When we return, we'll continue our conversation with him. We'll be right back. 2020 presidential election petition that's going on to the Supreme Court of Ghana. As we're speaking now, we're waiting for not to be opening their case. We wait to see exactly and hear exactly what's going to happen. But we're still engaging Dr. Kwekwajiman Budu, who is a lawyer. He's a law lecturer. He's also the head Law Center's Gimba Faculty of Law, and also the founder and executive director of the Justice Foundation. Doc, let's stay a bit within Section 72 of the Evidence Act and the Black Law Dictionary. Now, if you look at Section 72 of the Evidence Act, it talks about calling the witness or the evidence, the adverse witness. And the Black Law Dictionary also says that you're not an adverse witness if you're not in the box yet. How do we reconcile the two from the Black Law Dictionary's definition of who are adverse witnesses and from the explanation given in Section 72 of the Evidence Act that says that you call an adverse witness, but the Black Law Dictionary says that you're not an adverse witness until you are in the witness box? Hello?
Yes, can you hear me?
Yes, we can hear you now.
I just shared Section 72 on the screen. I hope you can see.
Shall we
See it? It's clear.
Yes. Yes, we can see it's clear.
So this is the provision that the petitioner is essentially saying that the ruling of the court was without due regard to this provision, to the extent that the court focused on the definition of adverse witness in the Black's Law Dictionary without averting its mind to this provision. And Section 72(1), as you can see, certain parts have been underlined for emphasis. Basically, it begins by saying, subject to the discretion of the court in a civil action, a party or a person whose relationship to a party makes the interest of that person substantially the same as a party may be called by an adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. So what I was saying was that first and foremost, this provision is discretionary. It gives the court that discretion, that ability to decide one way or the other when they are faced with competing positions. And so they can either exercise their discretion in favor of the party making that application or not. What the petitioner is saying is that the court did not even have regard for this provision, in the sense that he is suggesting the court did not appreciate the fact that the Evidence Act dealt with adverse witnesses, but went ahead to deal or to cite the Black's Law Dictionary's definition of adverse witness. And what I was saying was that this provision does not necessarily define an adverse witness, but it tells us the circumstances under which a person or a party may be deemed to be an adverse witness. And that can only happen with the discretion of the court, or with the court exercising its discretion in your favor to be able to call that party, which could mean your adversary, the defendant or the plaintiff, as the case may be, or a person whose interest is substantially similar or the same of that party. So for instance, if you've sued a husband and now you want to call the wife of that man to testify on your behalf, it is natural to assume that that person, the wife's interest, would be adverse to yours, because it is more likely that she would give testimony that will favor her husband and not necessarily favor you, the one calling that person.
Yeah.
But what the respondent was saying in response, which you Morris, I believe you talked about, was that the second respondent, or counsel for the second respondent, was placing emphasis on the last words in this provision, which says that all this that we've talked about, the fact that the court exercises its discretion and the fact that you may be given the option to call a party, it can only be done during the presentation of evidence by the one seeking to call that witness, who will be an adverse witness. Which means that it is when the petitioner was making his case that he could have exercised that option under this provision. That's basically what counsel for the respondent is saying, that it is when you are presenting evidence, when you are presenting your case, basically, that is when this provision will be applicable. But then we saw counsel for the petitioner basically suggest that that is exactly what they are seeking to do, because they are seeking to reopen their case for the purposes of presenting evidence. And so that's why I was saying that the only thing that we know for certain now is that all parties have closed their case, their respective cases, but the petitioner is now seeking to reopen his case to present evidence. So he's basically suggesting that he is not going contrary to this provision, and that the provision or the part which is saying during the presentation of evidence is applicable to them, assuming he is given the opportunity to reopen his case and thus adduce fresh evidence. And that's what I suggested earlier on, that the court itself, in giving its ruling on the 16th February, alluded to that if they are exercising their discretion to allow you to reopen your case, the same standards that have to be complied with when you are adducing fresh evidence is what has to be complied with at that point in time as well.
All right. So, per this review, what the petitioner is seeking fundamentally is to reopen his case. Now, there is an earlier ruling of the court which was even reviewed, and there was a final ruling after that particular review, which says that you cannot subpoena or compel a witness into the box. So now, even if this particular review, which the petitioners are seeking to reopen their case, is granted, there is another leg which says that you cannot force a witness into the box. I mean, so how do we, put the two together?
There are two different things altogether, and one has to do with the respondents closing their case and the petitioner praying the court not to case, because basically they said they were going to adduce evidence, so they should be compelled to adduce evidence. That's one aspect of what you're saying. Sure. The other aspect is the petitioner himself saying, now I want to reopen my case so that I subpoena the chairperson of the EC to testify as my witness, as an adverse witness. So that is the difference. There's a fundamental distinction between the court saying that the respondents are within their rights not to adduce evidence, and so their case, when they said their case is closed, their case is closed, and that is different from the petitioner saying, okay, now I also want to reopen my case so that I can cause a subpoena to be issued to compel the chairperson of the EC to testify. Two different things altogether.
Okay. All right. And Doc, we've seen about 3 review applications, and this is the 3rd one. Would it be fair to say that what we've seen in the first, second, we shouldn't expect anything different in the 3rd one?
I can't answer that question. What I can do is to take us through the grounds of review of this particular application, and we've done with the first one, which is the Section 72.
Yes, sure.
So if you permit me, I'll move on to the second and third grounds.
Let's move to the second and third, yes.
Okay, so because the petitioner argued the second and third grounds together.
Yes.
So ground 2 and 3, ground 2 is as follows, that the ruling was in fundamental error in that it subjected statutory provisions in the Evidence Act to the provisions of subsidiary legislation. And the ground 3 is that the court fundamentally erred in its interpretation of Order 38, Rule 3E5 of CI 47 as amended by CI 87. So these two grounds were taken together because they are similar. Okay. Basically trying to suggest that there was a substantive provision in an act of parliament, and the court rather relied on a subsidiary legislation to sort of override the express provisions of the Act of Parliament. So we need to look at what these provisions also say, what these provisions are, because that's what the petitioner is relying on. But before we even get to that point, the petitioner's argument is that the court made a fundamental error of law by subjecting subsidiary legislation to an Act of Parliament. And this is because, according to Article 11 of the Constitution, that sets out the laws of Ghana, it provides a hierarchy of some sort in terms of our laws, in terms of our laws. And it starts with the Constitution being at the apex. Then there are enactments made by or under the authority of Parliament, which will include an Act of Parliament. Then there are any orders, rules, and regulations made by any person or authority under a power conferred by this Constitution. The Constitution itself gives certain categories of persons and bodies power to make subsidiary legislation. It includes the Electoral Commission, which is given power to make regulations, for instance, for the conduct of elections, referenda, registration of voters, and all that. So they have that power. Then there's the existing law, which comprises of all the written and unwritten laws that were in force in Ghana prior to the coming into force of the 1992 Constitution, for so long as they are not inconsistent with the Constitution. And that's why we keep referencing NRCD 323, which is originally the evidence decree passed by the National Redemption Council in 1975. But because the provision of the Constitution enables or allows the existing law, that is, laws prior to the coming into force of the Constitution, NRCD 323, which has been christened the Evidence Act, even though enacted in 1975, is still part of the laws of Ghana because they are not inconsistent, or it's not inconsistent with any provision of the Constitution. So you notice that there are numerous acts of Parliament enacted by the first Parliament even, which are still on our statute books, like the Criminal Offences Act of 1960 and all that. So that's just the points that I want to make. Then there's the common law, which includes the doctrines of equity, the common law itself, as well as Ghanaian customary law. So these are the laws of Ghana, as espoused by Article 11. And the petitioner is saying that to the extent that the court in its ruling essentially suggested, and this is what the petitioner says the court was wrong on, that particular statement that the court made, that, and I quote, "We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumptions, is not applicable in this case in view of Order 38, Rule 3E5. And this is the basis for the argument of the petitioner, that to that extent, or to the extent that the court basically was projecting the orders in, or the provisions of subsidiary legislation above that of a substantive legislation, then the court had occasioned a miscarriage of justice. And this is the provision in contention here.
Section 20. Okay.
That's Section 20. I hope you can see it.
Sure, we can. Yes.
Yes. So Section 20, and once again, I've underlined some parts for emphasis because that is the sticking point in the argument. The provision provides that except as otherwise provided by law, including a rule of equity, and we just established that by virtue of Article 11 of the Constitution, rules of equity and common law, as well as the Ghanaian customary law, are even part of the laws of Ghana. Which means that this provision is not all-encompassing. This provision is recognizing that it is possible that there will be exceptions that have been provided by law including a rule of equity. It could include an act of parliament. It could include subsidiary legislation and so on and so forth. So, except as otherwise provided by law, including a rule of equity, when a party has, by that party's own statement, act, or omission, intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon that belief, the truth of the thing shall be conclusively presumed against that party or the successors in interest of that party in proceedings between A, that party or the successors in interest of that party, and B, the relying person or successors in interest of that person. So this is the provision that the petitioner is basing his arguments on, that this is substantive legislation in an act of parliament, or substantive provisions in an act of parliament, but the court has subjected this basically to subsidiary legislation. This is the provision that talks about conclusive presumption, the idea that because the respondent, the first respondent in affidavits before the court, for instance, had intimated that the petitioner could cross-examine her to elicit those answers that he wanted by way of interrogatories, she had acted in a way that the petitioners had acted upon the truth of that matter to their detriment because she had decided no longer to testify. And so this is what the petitioner is saying leads to a conclusive presumption, which should be what the court should uphold, that by making those statements and in the affidavits and filing the witness statement, it meant that she was going to testify, and that conclusive presumption should be made against her.
Right.
Is that clear?
But the respondents say that there's no point that the EC chair said she was going to testify.
Precisely. Sure. And in making that point and in making that argument, they rely on Order 38, Rule 3E of the High Court Civil Procedure Amendment Rules 2014 CI 87, 3E in particular, 3E 5. And that's what the court also ruled or said in its ruling, that, and this is what it provides, and you permit me to read. Rule 3E5 provides as follows, that if a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. So the court in its ruling, which is being challenged by the petitioner by way of the review, suggested that Section 26 of the Evidence Act, which we just projected not too long ago, was not applicable in view of this provision. And we know that Section 26 said, except as provided by law, including a rule of equity. And we've just talked about what the laws of Ghana are. So what the respondents are saying, basically, is that the petitioner should not or has misconstrued the ruling of the court to the effect that the petitioner is suggesting that the court was subjecting the Evidence Act Section 26 to the rules in the High Court Civil Procedure rules. But that what the true position is that by virtue of the fact that the Evidence Act itself in Section 26 begins by saying, except as otherwise provided by law, including a rule of equity, that exception or those exceptions that have been created can be contained in subsidiary legislation, one of which is the High Court Civil Procedure Rules, in particular Order 38, Rule 3E5. Is that clear?
Sure.
Yes. So that basically is the argument in relation to that. So on one breath, the petitioner is saying the court has subjected substantive legislation to subsidiary legislation. That shouldn't be the case because we know that in the hierarchy of laws, acts of parliament take precedence over subsidiary legislation, so that if there's any conflict between a subsidiary legislation and an act of parliament, the provisions in the act of parliament will take precedence. That's the argument of the petitioner, that the court had erred in that regard. The argument of the respondents is to the contrary, that the court has not erred because the substantive legislation that the petitioner is referring to in itself provide that there can be exceptions which may be provided for by subsidiary legislation, because it says, except as otherwise provided by law, including a rule of equity, which means that the number or the category of laws are not exclusive. It includes a rule of equity, which means there could be other types of laws that may provide exceptions to this general rule on conclusive presumptions in relation to a party's previous statements.
All right, so apart from subjecting Act, the Evidence Act 1975 to Order 38 Rule 3E5, I mean, apart from that argument of subjecting the former to the latter, doesn't the Evidence Act 1975, doesn't it stand alone for an argument? Doesn't it make sense on its own? I mean, for an argument from the position of the petitioner.
So that's what the petitioner is saying. That so the petitioner's argument basically is that in the hierarchy of laws, the Evidence Act takes precedence over the High Court civil procedure rules. That is clear. Everybody understands this.
Okay.
So he's saying that to the extent that the court stated categorically, and I quote once again for emphasis, this is what the court said, quote, "We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumptions, is not applicable in this case in view of Order 38 Rule 3E5. And the petitioner is saying that this statement basically means that the Supreme Court is subjecting substantive law, that is an act of parliament, or that which is equivalent to an act of parliament, the Evidence Act. It is subjecting that to subsidiary legislation, which shouldn't be the case.
Right. And they have said that's not the case.
Yes, and the respondents are saying that, and even the court, I believe, speaking through one of the justices, essentially suggested that is not what
that's what they're
saying.
Yeah, right.
And the respondents are saying that this cannot also be the case because the court, simply by saying that the Evidence Act is not applicable in view of Order 38, doesn't mean it is subjecting it to Order 38, but rather it is making that exception which Section 26 even recognizes, because Section 26 says or starts by saying, except as otherwise provided by law, including a rule of equity, that provision applies, which means that the law in itself recognizes that it is possible that that conclusive presumption which it is capturing, there may be exceptions to that situation, which may be provided for in law by virtue of subsidiary legislation or subsidiary laws, including even rules of equity, which in the grand scheme of things are even below CI 87, for instance.
Okay.
So that basically is the argument of the respondents in relation to that particular ground that the petitioner is seeking.
All right. Before we move to the third ground, so let's go for a quick break, and when we return, we'll move to the third grounds and other areas. To stay with us.
The fourth ground, actually, the two grounds were argued together. So
together, okay.
2 and 3 have.
Okay, stay with us. We'll be right back and look at the fourth ground. Stay with us. the Ghana Broadcasting Corporation, the state broadcaster for that matter. As of now, we're still waiting for the justices to return with their ruling on whether they will allow the petitioner to reopen their case. It's based on a review of their earlier decision that they took on the 16th of February 2021. We still have Dr. Kwekwajiman Budu here with us, and we're talking about some of the issues that came up. We've looked at 1, 2, and 3 grounds of the petitioners. We're moving to the 4th one. Then we'll touch on other issues and still anticipating what the judges are going to say. Doc, good afternoon this time around. Let's move to the 4th one.
Yes. So the 4th ground is captioned or is put as follows: that the ruling of the court was per incurium. And once again, you need to explain what per incurium. Per incurium simply means without due regard, or without referencing, or without regard for Order 38 Rule 10. So the ruling of the court was per incurium, Order 38 Rule 10 of CI 47 and Section 58 of the Court Act of 1993, Act 459. And so this is what I'd like to share once again, the screen, so that we appreciate what we're talking about. So, can you see?
Sure. Yes.
So this is Section 58, which the court is saying that, which the petitioner is saying that the ruling was without regard to Section 58 of the Courts Act, as well as Order 38. We'll come to Order 38, Rule 10 subsequently. Section 58 of the Courts Act provides as follows, and once again, I've underlined that part for emphasis because that is the matter in dispute, or that's one of the what there seems to be some confusion about. It provides that in any proceedings and at any stage of the proceedings, a court, either on its own motion or on the application of a party, may summon a person to attend to give evidence or to produce a document in the possession of that person or excerpts from the document subject to the applicable enactment or the relevant rule of law. So I think once again, we probably should have underlined or should underline the last part of this provision. It says, subject to the applicable enactment or the relevant rule of law. So this is what the Court Act provides, that in any proceedings and at any stage of those proceedings, the court can either suo motu on its own motion, or if a party makes an application, the court may listen to that application and decide that application, and may decide to summon, may, keyword being may, which shows you that is discretionary, it's not as of right, may summon a person to attend to give evidence or produce a document that may be in that person's possession or excerpts thereof from that particular document. So that's one of the provisions that the petitioner is saying the court's ruling was per incurium, was without regard to that. The second provision has to do with Order 38 Rule 10. Unfortunately, we can't project that. But Order 38 Rule 10 has to do with writs of subpoena or a writ of subpoena. And as we've explained before, a subpoena is simply an instrument or court document which is issued by a court for the purposes of summoning the appearance of a person in court proceedings for the person to either testify and or produce a document which is in that person's possession, which we saw in Section 58. It makes reference to the fact that the document may be in possession of someone and he may be summoned to come to court. So on the basis of Section 58, it means that generally speaking, it is possible for a court to summon a witness or witnesses either on their own or upon an application by a party, but we note that this is discretionary, which once again means that the court has the choice, especially if there are two competing positions, to decide one way or the other. And such summoning of witnesses in relation to proceedings before the High Court, for instance, assuming the application is made and is successful, will be done pursuant to Order 38, Rule 10 to 13 of the High Court Civil Procedure Rules of 2004, CI 47. And that's the other provision that the petitioner is saying the court's ruling was without regard to Order 38, Rule 10 of CI 47. And under Order 38, Rule 10, a request must be made for the issuance of the writ of subpoena from the registry of the court which a writ is to be issued. And once this is properly done, a writ of subpoena testificandum or ducis tecum may be issued in the prescribed form, I believe Form 14, and it shall then be sealed, after which it will be served personally within 12 weeks, I believe, from the date or after the date the writ was issued. So it's clear at this point that generally speaking, it is possible for witnesses to be summoned or subpoenaed in court proceedings in Ghana. And as a matter of fact, to even make the point much clearer, there are consequences for non-attendance by witnesses who have been duly summoned.
Right.
And it actually constitutes a criminal offense under the Courts Act, as it amounts to contempt of court. And so if you are summoned and you fail to appear, you may be fined or you may be imprisoned. I think the fine is up to 50 penalty units or so, or an imprisonment term of up to 6 months, or to both the fine and the imprisonment. But we need to take our minds back to Section 58, which we projected, which says in any proceedings and at any stage of the proceedings, which was underlined, the witness may be summoned subject to the discretion, at the discretion of the courts, but subject to an applicable enactment. And so the applicable enactment will probably in civil proceedings of this nature, similar nature, may be the Evidence Act, which provides in Section 72 the use of an adverse witness, for instance, in civil actions, which itself is subject to the discretion of the court and also can only be done at any time during the presentation of evidence by the party calling the witness, which seems to be in debate here because the respondent is saying you've closed your case, so you are not presented evidence, and so this Section 72 is not applicable. And the petitioner is saying, well, that is why I'm seeking to reopen my case to be able to present or lead fresh evidence, so it's applicable. But we need to understand that by virtue of this provision, there is a time frame which has been prescribed within which witnesses may be called or treated as adverse witness or summoned thereof by the court if you're looking at the circumstances of that particular case, which means that the application to treat a witness as an adverse one or to call a witness whose interest may be adverse to yours must be made when you are presenting your case and not after you have closed your case. And I think the petitioner generally agrees with that fact, but it's further saying that because of that, that is why I want to reopen my case, to be able to cause the subpoena to be issued. So in the circumstances, for instance, where one party, say, a plaintiff has closed his case, he may then decide to probably seek the leave of the court, probably in the interest of justice, for instance, to reopen his case and to do a number of things. For instance, he can decide to cause a subpoena or pray for a subpoena to be issued, to be served on a particular witness, which we've already noted is at the discretion of the courts, so it's not as of right.
All right.
Or where a potential witness, for instance, has filed a witness statement but has not been called to testify, the party who is seeking to reopen his case, and assuming the prayer to reopen the case is granted, he may decide to put in that witness statement as hearsay evidence in accordance with Order 38, Rule 3E5, which we have already talked about as well. So those are the arguments surrounding this particular ground that the court, basically the petitioner is saying the court didn't have regard to these provisions that we talked about when it decided to dismiss their application to reopen their case. And the respondents obviously are arguing otherwise, basically suggesting that it is the same argument that they are making and that they have not been able to show what the exceptional circumstances are that have occasioned a miscarriage of justice, because that is key in invoking the review jurisdiction of the Supreme Court.
Right. So before you look at the other grounds, I think E and F. If you look at a lot of the laws, whether it's Section 72 of the Evidence Act or Order 38 Rule E, which the petitioners say the justices didn't make reference to or are per incurium, as you said, it does appear that almost all of them are discretionary. Is that why maybe the justices will not make reference to that? Because at the end of the day, even if you applied, it will be at our discretion to grant that.
I can't tell why the justices will make or not make reference to particular provisions. What I can say is that the provisions that we're talking about in terms of discretion generally, and we've explained that discretion simply means that the court has to, when faced with two competing positions, they may decide one way or the other on the basis of the merits of the arguments that are made in respect of the respective positions, competing views or positions before it. So I can't say why or if. I mean, we should stay away from trying to preempt or the ruling that it's about to be given by the Supreme Court, or try to go into the minds of the justices and all that, because it's not possible. At least it's not possible for me sitting here to do that. But generally, when we say that you have a discretion, or where a statute or rule or law provides a discretion to the court, what it simply means is that you, the applicant, are not entitled to it as a right. And that's why applications are made. And once again, I'll refer you to, or refer our viewers to, the statement that was made by His Lordship the Chief Justice, I believe in one of the rulings, or after he had given one of the rulings. I think it was the second ruling in relation to the
and that was on the 11th of February.
Yes, the 11th, where His Lordship the Chief Justice stated clearly that the court deals with applications as and when they are brought before it. They do not determine whether parties will or should make applications. If the parties choose to make applications before the court will decide on them on the basis of the merits of the application, the arguments that are advanced for and against the respective positions that are advanced. But the court will exercise its discretion in certain circumstances sparingly, which means you need to meet a very high threshold for the court to exercise its discretion in your favor, or one way or the other. And so that's what we can say about discretion. The other thing we can say about some of these provisions which we have projected is that they seem to not be all-encompassing, in the sense that either they are subject to some other law, or it makes provisions for the fact that there may be exceptions to the general rule that is being espoused. And that is something that is normal in lots of legislation, because in as much as the lawmaker wants to make a point or provide for something in particular, it is possible that exceptions will also be provided. So you normally see that in almost all laws, or lots of laws, there are general propositions of law, and there are exceptions to that general law, which does not necessarily make it contrary to that initial proposition of law.
And yet again, we'll come to ground E and F. But at what point will a lawyer or counsel be said to be abusing court processes?
When you make frivolous, vexatious applications that are unwarranted, not merited, and just attempts to waste the time of the courts, then you can be deemed to be basically abusing the court process, when you know for a fact that there's no merit whatsoever to applications that you're making, and you're simply trying to waste the court's time and all that, that may be deemed to be you abusing the court processes, which generally lawyers are not supposed to engage in.
Are there any sanctions?
The application may be dismissed. In some instances, costs may be awarded against you. And if you remember, in the last time we were here, I think on Thursday, counsel for the second respondent sought to urge the court to grant costs against the petitioner because of what counsel for the second respondent felt was an abuse of the court process. And His Lordship, the Chief Justice, once again made the point clear that in constitutional matters, it was a well-settled practice that costs were not granted against parties. But generally speaking, that would be one of the consequences that if you bring frivolous, vexatious applications, costs, simply put, you will be fined. Let me put it that way in simple terms. You'll be made to pay money to the opposing party simply for wasting everybody's time and all that.
And who determines that the process or you're abusing court processes? Who determines that?
I mean, it depends. The court on its own can come to the conclusion that you are abusing the court process. It's not necessarily up to any of the parties to suggest conclusively that one party or the other is abusing the court process. Obviously, a party may feel that the other party is abusing the court process and may urge that on the court. But once again, it has to be on the merits. You need to be able to show that indeed everything or what you are referring to actually constitutes an abuse of the court process, in the sense that the applications are unmeritorious, they are vexatious, they are frivolous, they have no merit whatsoever, and things of that sort. But ultimately, the court will come to that conclusion or will make such a determination.
Does abuse of the process also include flouting the orders of the court?
Abuse? It depends on how you want to look at it. I mean, if the court gives specific orders and directions and you do not comply with those orders and directions, there may be sanctions that may be imposed on you. For instance, in an election petition, where a petitioner fails to comply with the orders of the court in relation to certain processes that he has to comply with, the court even has the power to dismiss the petition there and then and strike it out. In the same way, where respondents also fail to comply with orders or directions of the court in relation to filing certain processes, including their pleadings or something that has to do with their answer to the petition, the court may proceed to hear the petition without having regard to anything that the respondents would have to say, as they have not complied with the court's direction. So to the extent that there may be consequences to you not following or a party not following or complying with court orders, the argument can be made. I don't know, in my mind, I don't know whether that would amount to an abuse of the court process per se, especially when you look at frivolous and vexatious applications, which clearly are an abuse of the court process. But in the other breath, it may just be that it's also serious, it's disrespectful, the court's orders and all that. And so, I mean, if you want to look at it in terms of being an abuse of the court process, you may, but I'm not too sure in my mind whether that can specifically be categorized as an abuse of the court process. But that notwithstanding, there will be consequences, or there are consequences for failure to abide by directions and orders of the court.
Right. So at this point, you want to take us through the ENF of the petitioner's motion, which is currently before the court.
Briefly, yes. So basically, the ground E of the petitioner's grounds of review is that the ruling of the court, once again, was per incurium, Article 1913 of the Constitution of Ghana, and has thus occasioned a grave miscarriage of justice to the applicant. And Article 1913 of the Constitution provides for the right to a fair trial in civil proceedings. And basically, what the applicant, the petitioner, is saying is that they are entitled to be given a fair hearing because the Constitution makes that point clear in Article 1913, and they believe that as a result of the fact that the court did not avert its mind to Article 1913, basically, the court had acted contrary to the provisions of Article 1913, giving them the right to a fair hearing, and as a result, they believe that a miscarriage of justice had been occasioned in that regard. Similarly, ground F, which is the last ground, provides that the ruling of the court was in breach of Article 296 of the Constitution, and as a result, had also occasioned a grave miscarriage of justice. And Article 296 of the Constitution is simply captioned exercise of discretionary power. And it provides as follows, and with your permission, I would read that where in this Constitution or in any other law, discretionary power is vested in any person or authority, that person, that discretionary power shall be deemed to imply a duty to be fair and candid. The exercise of the discretionary power shall not be arbitrary, capricious, or biased either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. And finally, where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this Constitution or that other law to govern the exercise of the discretionary power. So basically, it is the first two provisions, 296A and B, that the petitioner is basing this ground on, that the court breached Article 296 in the sense that the court does not exercise its discretionary power in the proper way. And so because in the view of the petitioner, the court had exercised its power contrary to that which is provided for in Article 296, they believe that the court had occasioned a grave miscarriage of justice to the petitioner, and as a result, they were entitled to the review that they were seeking the court to review its own ruling. So that basically are the grounds, the last two grounds that the court is faced with, or the petitioner has brought to try to reverse the earlier ruling of the court that it gave on, I believe it was 16th February 2021.
All right. Doc, on the discretionary powers, is there a means to determine that based on that powers, that those powers are being abused by whoever is exercising that particular power?
So that's what the petitioner basically is arguing. The petitioner is arguing that the court has not exercised its discretionary power properly, and that there are standards that you have to meet, that the court can't just act arbitrarily or capriciously, and that in exercising their discretion, the discretion should be grounded in law and not out of fear or favor or ill will towards any party or it being capricious and all that. So basically what the petitioner is saying, that yes, in as much as the court has discretionary power, the court has discretion whether to decide one way or the other, the discretion is not exercised in a vacuum. The discretion has to be grounded in law. And that's basically what the petitioner is saying in those ground that seeks to talk about discretionary power.
Okay, nice. All right. Doc, we'll leave it.
Before you break, we need to remind ourselves, now that we are waiting for the court's ruling on this particular issue, we need to remind ourselves what the court said in the ruling that has led to this particular review application, and in relation to the standards that ought to be met if the court is to exercise its discretion in favor of a party to allow it to reopen its case. Just because we're talking about discretion, I wanted to chip this in. This is what the court said in relation to when you want to reopen your case, that in weighing the propriety of reopening proceedings to permit new or additional evidence to be led or tendered, the court will typically consider the following broad questions, and there are 5 main questions that the court suggests that they have to consider it, and essentially the petitioner has to answer these questions favorably in order to have the discretion exercised in their favor. Number 1, the question is, would the evidence that they are seeking to adduce by virtue of reopening their case, would that evidence, if it had been presented during the trial, would it have had any influence on the results? That's the first question that the petitioner must answer. Number 2, could the evidence have been obtained before or during trial by the exercise of reasonable diligence, which means that the petitioner needs to answer that there was no opportunity for them to have obtained that evidence that they are seeking to introduce during the trial as a result of due diligence. Number 3, the question is, what is the relevance, necessity, and materiality of the proposed evidence? So the petitioner needs to show that the evidence that he seeks to introduce is relevant, is necessary, and is material in that particular instance in the petitioner's case. The 4th question is, what is the effect, if any, the reopening of the case may have on the expeditious trial process? So the petitioner needs to also show that in seeking to reopen their case, it is going to be in line with the fact that the trial needs to be done expeditiously and must not be unnecessarily delayed. So that the petitioner needs to answer that question. And then finally, the 5th question is that will the other party be prejudiced, that's the respondents? Will they be prejudiced, that's in, will they be affected, materially affected, if the reopening is allowed, or a miscarriage of justice perpetrated if it is not? So here basically the court needs to balance the respective positions of the parties. 1, they need to seek to see if whether reopening may be in the interest of justice, because a miscarriage of justice may have been occasioned to the petitioner. But in the same vein, the court also needs to see whether reopening will prejudice the respondents in some way or materially affect the respondents in some way, which may lead to consequences of its own, which may even affect the expeditious trial process that we are talking about. So in a nutshell, these are the 5 questions that the court said the petitioner needed to respond to, or the court had to consider in exercising its discretion to allow the petitioner to reopen their case. And this is basically what the court said. They had not been convinced that the petitioner had answered those questions positively to allow the court discretion to be exercised in their favor. And it is against this ruling that the petitioner is seeking review from the Supreme Court, which we are waiting for the ruling as of now.
Okay.
All right, so Doc, we will have to, break here. We're seeing pictures from the Supreme Court. It does appear that they may be resuming anytime soon, but we are still here in studio as and when we get a signal that the Supreme Court has resumed. We'll take you to the Supreme Court to hear that ruling of a review of their own decision they made on the 16th of April, which says that the petitioners cannot reopen their case and subsequently subpoena the EC chair to mount the box to be cross-examined. And so we are still here, George.
All right, we have
a signal.
All right, 23 minutes to 1 is the time. We're going for a quick break, and as we await for the justices to return, we'll go for a break. Stay with us.
ought to be bound by. He submitted that in law, the statement that he was available for cross-examination was to be conclusively presumed against her under Section 26 of the Evidence Act 1975 NRCD 323, and this should form the basis on which the court should order her to testify as a witness for the petitioner. He submitted further that it was the intention of petitioner to call her as an adverse witness pursuant to Section 72 of the Evidence Act. Counsel for petitioner failed to indicate to the court the nature of the subpoena he intended to issue and what kind of testimony exactly he was expecting the chairperson or first respondent to bring to his aid in her personal capacity. It must be understood that under Order 38 Rule 10 Sub 1, the writ of subpoena a party may issue to invite a witness may be a subpoena ad testificandum to compel the witness to testify, or ad tecum to compel the party to produce documents in support of the party's case. Counsel for petitioner variously said that the chairperson of EC is to testify to the court on the truths behind the errors that the petitioner has outlined from her declaration in his petition, and also to account for how she conducted her constitutional duty as a returning officer for the presidential elections, particularly with the final collation of voting returns resulting in the Form 13 and the CI 127. This application to reopen his case for the sole purpose of issuing a subpoena to the chairperson of the first respondent to appear and testify as an adverse witness for the petitioner after all the parties had closed their cases was dismissed because the court in its ruling and the review clarified that the application was not supported by any law or settled practice. As a policy court and a court whose decision must be followed by all courts, we set out in our decision of 16th February 2021 the settled boundaries that every court must comply with if called upon to exercise their discretion and allow a party to reopen their case for the admission of new evidence. They are in two broad areas as follows. One, would the evidence, if it had been presented during the trial, have had any influence on the result? Two, could the evidence have been obtained before or during the trial by the exercise of reasonable diligence? The review jurisdiction of the Supreme Court is properly invoked under Rule 54 of the Supreme Court Rules 1996 CI 16 and requires the satisfaction of two grounds. A, exceptional circumstances which have resulted in miscarriage of justice. B, discovery of new and important matter or evidence which after the exercise of due diligence was not within the applicant's knowledge or could not be produced by him at the time that the decision was given. Counsel for petitioner has asserted that it amounts to a fundamental error for this court to A, fail to find that the first respondent depositions about being available for cross-examination should be conclusively presumed against her, such that she should be compelled to testify as a witness of the petitioner. He urges that this failure to properly construe Section 26 of NRCD 323 is a fundamental error of law. He also urges that this court's construction of adverse witness by relying on the definition contained in Black's Law Dictionary instead of Section 72 of Evidence Act constitutes another fundamental error. Third, he urges that by dismissing the petitioner's application to reopen his case for the sole purpose of calling the electoral commissioner as a witness of the petitioner, this court is shielding her and enabling her to evade cross-examination, contrary to a position she had deposed to earlier in the processes in this petition. It is the position of counsel for petitioner that the chairperson of first respondent is required to appear and testify to the truth of what happened in the election in dispute to account to the people of Ghana for her stewardship as the returning officer of the presidential election, for which she had issued a first declaration and corrected that declaration with a press release the next day. She was also required to clarify matters arising during the cross-examination of the petitioner's witnesses. We disagree with counsel for the petitioner on all these grounds, urging alleged fundamental errors as constituting exceptional circumstances. This is a court of law and not a forum for suppositions. It must be stated that courts of law administer justice in accordance with law and settled practice, and no court can afford to lose sight of this. Further, this is the highest and the last court of the land, and our decisions on the questions of law have binding effect on no other courts. That before this court accedes to any application that is not covered by statute, the rules of court, or known general principles of law applicable in this jurisdiction, this court must ensure that it's not opening a Pandora box that can become a stepping stone for abuse of court processes at other levels of the judicial system. The interest of justice is not only the interest of one party in the dispute, but must necessarily be an outcome arrived at through the proper balance of what the law has prescribed as the duties of the court to all parties and the duties of the parties to each other. Thus, when the court has to exercise discretion in an extraordinary situation, such as a party seeking to reopen his case after all parties have closed their cases, the court has to ensure that the discretion is consistent with statute, rules regulating procedure, principles of law, and settled practice of the courts. We have earlier in this ruling set out the guidelines that all courts must follow when determining applications for leave to reopen a party's case at any time after they had voluntarily closed their own case. Applicant has urged that this court failed to appreciate the import of Section 26 of the Evidence Act, NRCD 323. This submission is misconceived because we fully appreciated the submission of the petitioner's counsel, and found them wholly unsupported by any rule of law or rule of equity to which the conclusive presumptions is made subject. It is not the case, as urged by counsel for petitioner, that we allowed Order 38 Rule 3E5 of CI 47 as amended by CI 87 to take precedence over a substantive act of parliament. The Supreme Court reviewed the legal principles on the equitable doctrine of promissory estoppel that has been captured in Section 26 of the Evidence Act in the case of Clipper Leasing Corporation versus AG and Ghana Airways in liquidation, 2016, 100 GM, 1 Supreme Court. The holding of the court clarifies that for a statement to constitute conclusive presumption, it must be a statement of fact, and it must be clear, unequivocal, unambiguous, and unconditional. The promissor must have intended the promisee to act upon it, and the promisee must show that he acted on it and altered his position. Further, all the circumstances of the case will be taken into account in granting relief, and the usual maxims of equity will apply. From this premise, the first question to ask when a party alleges that a statement must be conclusively presumed against the maker of the statement is, was the promise clear, unequivocal, unambiguous, and unconditional? Was the promise and the context of the promise such that the promissor intended the promisee to act upon it? Did the promisee show that he acted on it and altered his position? In the context of the case before us, we are satisfied that the positions in issue cannot satisfy the minimum threshold of being clear, unequivocal, unambiguous, and unconditional undertakings of the first respondent herein to defend itself in this suit. At the time the depositions were made, the first respondent had already given notice in his answer that it considered the suit as disclosing no reasonable course of action and had gone on to file its submissions with respect to that position. All three parties had filed their submissions on this point. We found this to be the most determinative factor, that these depositions cannot be construed as clear and unambiguous undertakings that could give rise to a conclusive presumption that the first respondent will be defending itself in this suit. Again, the depositions were made by the chairperson of the first respondent as a representative of a party in this suit, and not in her personal capacity as a party in the suit. The decision whether or not to testify in the suit could only be that of the commission and not hers. The decision whether or not to personally testify on behalf of the first respondent commission is also not available to the chairperson because he is not a party to this suit. Further, cross-examination is only possible if there is examination in chief. Thus, if the first respondent, which is an organization, decided after the petitioner closed his case not to defend itself, the statements made as part of an affidavit in opposition indicating the options the petitioner could exercise if the interrogatories and other applications were disallowed cannot be said to have been unambiguous undertakings to submit either the commission through the chairperson or any other officer to cross-examination in a suit that it had not offered testimony in chief. Counsel for applicant has also urged that this court failed to consider Section 72 of the Evidence Act, but rather relied on the definition in Black Law's Dictionary, and so the ruling under review was per incuriam. We find no merit in this submission. Black's Law Dictionary is a respected and reputable source book for the bench and legal practitioners. Reference to law dictionaries is an accepted and respectable practice in common law jurisdictions, including Ghana. Furthermore, there's no inconsistency and contradiction between the definition in Black's Law Dictionary and Section 72 of the Evidence Act, as already determined by the Supreme Court. In Re Okan disease, Dodu and another, versus Okan and others, 2003-2004, one Supreme Court of Ghana report, page 582. We are satisfied that it is the nature of testimony proffered by a witness that allows a court to categorize that witness as an adverse witness or hostile witness, and not the description of the witness as such. And so the submission that the witness was to testify as an adverse witness was no answer to the need to clarify the objective of seeking leave to reopen the case and call the chairperson or the first respondent as a witness of the petitioner. Section 72 of the Evidence Act provides 72(1). Subject to the discretion of the court, in a civil action, a party or a person whose relationship to a party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. When such a witness is cross-examined by his own lawyer or by a party who is not adverse to the party with whom the witness is related, that examination is to be treated as if it was a re-examination. Clearly, the positive part of the provision in Section 72(1) is the fact that the person who calls such a witness has an interest that is adverse to that of the witness, and he is allowed to cross-examine the party he has called, and not that he merely described the witness as an adverse witness on the application to call the witness. In Re Okan disease, Dodu and another versus Okan and others, Supra, the Supreme Court had the opportunity to review the distinction between an adverse witness and hostile witness. The court was clear that being an adverse or hostile does not arise from the description given by the party who called the witness, but the nature of testimony given by the witness. First, Dr. Sechum JNC had this to say in clarification on the general nature of witnesses and the specific nature of adverse and hostile witnesses at page 599. Quote, as a result of the testimony of the third plaintiff witness, namely that he did not see either the testator or the second plaintiff witness sign the will, counsel for the executors applied for permission to treat him as a hostile witness. Learned counsel for the defendants was right when he submitted that the witness should be rather treated as adverse witness and not as a hostile one. The reason is that any attesting witness will be a witness of the court and not that of the party calling him, end of quote. Professor Kluje JSC went on to state as follows from page 626 in his evaluation of when the witness is an adverse or hostile witness and the effect of the testimonies of the two types of witnesses. Quote, the trial judge, with the benefit of observing the witness, may choose to believe an adverse witness or part of his testimony. The fact that a witness called by a party gives an adverse or contradictory testimony does not lead to the irresistible conclusion that the adverse witness is an untruthful witness. The witness may be an adverse witness precisely because he insists on telling the truth rather than commit perjury in support of the fabricated story of the party who called him. Usually, it is difficult to determine whether the witness is merely adverse or hostile when there is no previous statement by him with which he could be confronted. In my view, a witness is a hostile witness if it can be shown that he knows the truth but deliberately persists in lying to the court. There may be different ways of arriving at that decision, end of quote. We did not see any fundamental error occasioned by this court's evaluation of whether the chairperson will be an adverse witness merely by her description as such by counsel for petitioner, even before she brings any testimony to the court. The issue that was determined by the ordinary bench is whether it is proper for the court to exercise judicial discretion and allow the petitioner to reopen his case for the sole purpose of calling the chairperson of the first respondent as his witness by the issue of his subpoena. Our determination was that it would not be a proper exercise of judicial discretion, and we do not see the miscarriage of justice that our decision occasioned, since petitioner continues to insist on not disclosing what new material the proposed witness is to testify on, and how that new evidence can change a judgment that is yet to be given. Counsel for petitioner also contends that the ruling was in breach of Articles 19, Clause 13, and 296, as it was unreasonable and irrational. Counsel for petitioner failed to draw the court's attention to any unfair exercise of judicial discretion exhibited by the Supreme Court against the petitioner, just because the court refused his application to reopen the case he had closed and to serve a subpoena on the EC to serve as an adverse witness. He would like to reiterate a time-honored principle of the adversarial system we operate, quoting the Supreme Court in Clipper leasing case again. Quote, the well-known policy of the law is that parties to a case in court are to know exactly what is that they are required to answer, and this is a requirement of fair hearing that the courts insist on. The requirement of fair hearing is a fundamental rule of natural justice, so a party cannot change its case on appeal when the opponent has no opportunity to adequately defend himself and lead requisite evidence in his or her defense. The petitioner purported to present his full case in the witness statement submitted after the depositions in issue had been made. On the strength of those testimonies, including that of a third witness petitioner later called, respondents closed their respective cases. If the petitioner intended to rely on the depositions in issue, the law required him to state as part of the testimonies he would rely on the specific testimonies or documents he wanted the chairperson of the first respondent that petitioner has summoned before us to produce to aid the petitioner's case on the alleged strength of the depositions. As part of pre-trial processes, the parties and this court could have had the opportunity to tell me if truly the documents were not available in petitioner's custody, as happened in the application to produce originals of the polling station results, or the testimony sought was relevant to the settlement of the matters in controversy in this petition, as happened in the application to serve interrogatories. Statutes are construed and applied as a whole. No party or court may take part of a law and urge it to be applicable while ignoring the rest of the statute. Sections 10 to 14 of the Evidence Act lays down the burden of producing evidence and the burden of persuasion squarely on the party that alleges any position of fact or issue of law. Further, we stick to the time-honored principles that the Supreme Court has adopted in circumstances in which it reviews its decisions. Thus, in the case of Mechanical Lloyd Assembly Plant versus Nati, 1987-88 Ghana Law Report 598, page 603 to 604, and the DJS stated, quote, let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer, along with the evidence grounding it, can be criticized in the same way as a high court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision would be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. The review jurisdiction is a special jurisdiction to be exercised in exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in exceptional situations when a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor is it an automatic next step from appeal. Neither is it meant to be resorted to as an emotional reaction to an unfortunate unfavorable judgment. Secondly, in Chapel Hill versus Attorney General and another 2010 Supreme Court of Ghana report, page 827 at 850, the Tiban JSC further set out the parameters for reviews as follows. Quote, I do not consider that this case deserves any lengthy treatment. I think that it represents a classic case of a losing party seeking to re-argue its appeal under the garb of a review application. It is important that this court should set its face against such endeavor in order to protect the integrity of the review process. This court has retreated several times without number that the review jurisdiction of this court is not an appellate jurisdiction, but a special one. Accordingly, an issue of law that has been canvassed before a bench of 5 and on which the court has made a determination cannot be revisited in a review application simply because the losing party does not agree with the determination. This, unfortunately, is the substance that the current application before this court is. End of quote. The application and the review was dismissed because it was not based on any known law or rules of practice. We dismiss the instant application as being wholly without merit.
As the court pleases. You are grateful to the court. We are most grateful.
Yeah.
The panel will be reconstituted. All rise.
Not the same.
By court, the motion for stay of proceedings is struck out as withdrawn.
Most grateful.
Yes.
As I move the motion for leave to file our address after the date ordered by the court, I move that applications in terms of the motion paper and the supporting affidavit. And my lords, as we've indicated, the affidavit in support is sworn to by counsel in this particular case for obvious reasons that appear on the face of it.
My lords, we are opposed to the application. We are opposed to the application, and we are opposing it by virtue of Rule 69C of CI 99, and also, my lords, by reference to the case of Republic versus High Court, Tamale, ex parte Dapem Zobuguna Henry Kalim, civil motion number J5/6/2015, judgment of the Supreme Court dated 4th June 2015. Lords, in that case it was held that the bare fact that an application for stay of proceedings has been filed does not operate as an automatic stay, so no party has the privilege to stay away from proceedings as the applicant did at the court below. Lords, if we look at the affidavit in support, the applicant or the petitioner is brazenly telling the court the reasons why he has refused to comply with the orders of the court. When established practice and the decision of this court is that the mere filing of a stay does not amount or give you the right to stay away from proceedings, because this is the highest court of the land, and I think that obeisance to the rules and orders of the court are part of our practice. And so far as the positions clearly show that yes, I chose not to comply with the orders for my own reasons, I pray that this application be refused. Your Ladyship, 69C of CI 16 as amended by CI 99. Yes. The 4B, Your Ladyship, with your kind permission, the court may dismiss the petition where the petitioner fails to file the processes regarding the petition within the specified time. Laws.
But we've had the case to conclusion.
Pardon?
I said we've had the case to finality. We are left with only closing addresses.
Yes, my lord, it's part of the processes that we file.
My lords, we are opposed to this application to the extent that the petitioner is not seeking the magnanimity of the court.
But what is he seeking?
He is asserting a right. My lords, the petitioner, my lords, if your lords would refer to paragraphs 10, paragraphs 13, paragraphs 15, and paragraphs 14 of the petition. My lords, of the affidavit in support. My lords, the petitioner is seeking to tell the court what is convenient for it. So it says in paragraph 10, it would not be ideal for me to have to file a closing address without the testimony of the chairperson. In other words, the court has directed him on the 11th of February that we should all file closing addresses by the 17th. And he elects to tell the court that it will not be ideal for him to file, to comply with the court's order. On what basis can a party tell the court much more the highest court of the land?
It's coming from a friend on the other side. No, it's coming from my lord. That's the position in the affidavit you are referring to.
Yes. So, my lord, I'm saying that this deposition is a direct defiance of the court's order.
For leave to find
but it's in the leave, in their application for leave. It's an example of the defiance. My lord, that's what I'm saying. That it is one thing for them to come to this court contrite, and therefore the court should grant them leave. But they are trying to justify what they did. They are defiance of the court's order. So, my lords, they may be advised to withdraw those paragraphs, offending paragraphs, and just plead to the court that they be granted leave. But this attempt to justify the unjustifiable.
So, comparing only the decisions, which is to assert a right?
Yes, because the application is based on the depositions. So they may choose to advise themselves and withdraw those depositions, of offending depositions. So that, because, my lords, if this court grants this application on this basis, it will set a precedent. It will undermine the court's well-established authority that a review application is not a stay of proceedings. Secondly, that a party who files an application for stay is not entitled to stay until the court grants it. Those are two very important, principles of this court. And if the court grants this application based on these depositions, it will be undermining those principles. So our view is that it's all fair for the court to grant the applications, but it cannot be based on these depositions. No, it cannot be. And finally, my lords, they have arrogated to themselves the proposal of when they file. No, yes, I know that will be left to the court. But, my lord, will you hear me out? They have already had, since the 17th, since the 11th, now it's about how many days? 11 days. And they're asking for a further 72 hours. Meanwhile, we, under pressure, have met the court's order. So if they are seeking the court's leave, they should be filing this thing either by the end of the day or latest tomorrow, my lords, because they have indicated to your lordships that they already have a draft.
Yes.
But my Lord, again, like their samples, they are saying this is a draft, so that it will give them the opportunity to go and produce something completely different from the draft.
Order in court, please. Order.
My lords, I will not dignify some of the comments on our conduct. My lord, there have been very serious comments made about our conduct, which I will not dignify with a response. I will not dignify them with a response, because saying that we filed something and then we'll go, I mean, these are serious allegations, but I do not wish to dignify them with a response. That's what I wish to say. I only wish to say respectfully that we have come to this court asking for leave. And in indicating that we are seeking leave, we have adverted in our affidavit to certain factual realities that we have had to deal with. Those factual realities include the fact that we have filed applications for review before this court. Those applications have been heard by this court and they have been dismissed. But we could not have contemplated that those applications would necessarily be dismissed, because we did not believe that there were predetermined outcomes for those applications. That was not the basis on which we proceeded. We did not believe that. And because we did not believe that, we took our time to deal with those review matters in the hope that after the review, we might have the chance to have a witness testify. The court has this morning decided, or this afternoon, the court has this afternoon decided.
My lords, with all due respect, my lords, he can respond on points of law at this stage. No, please, my lord, that is the process I mean.
Please, if the bench wants to say something, you defer to the bench, please.
Very well,
Mr. Kutempa,
very well.
Before he could move the application formally, I had wanted to know whether any of you were opposing it. It is normally done in practice just to, as to manage time. So, well, I anticipated that, well, this is a colleague on the other side who has sworn to an affidavit explaining his inability to do that. He has annexed a proposed, normally we call it a proposed, not a draft, a proposed statement of case or whatever. So I thought that you were not going to oppose. That was why I cut him short and decided to ask whether you were opposing it or not. It is normally done.
Very well, my lord.
Yeah.
And my lords, in the affidavit in support, these clear circumstances in which we have found ourselves have been put before you. As a matter of fact, the paragraph 10 that counsel for the second respondent found so offensive. My lord, with respect, there is no offense to this court in the lawyer saying it would not be ideal for me to file a closing address without the testimony of the chairperson and then have to file a separate further component of should the review application be so. That is a very simple statement of the reality that we find ourselves in. So, my lord, rather than get into all these things, we have given an indication to the court, and we say in paragraph 13, the deponent says in paragraph 13, I will crave the indulgence of the court to allow. We did not arrogate ourselves we did not arrogate to ourselves a time frame. The position is very clear. I will create the indulgence to allow, and this just gives an indication to the court of a time frame within which it will be feasible to file. How can anybody interpret paragraph 13 as imposing on the court or as not being, as not recognizing what the court's authority in this? The very heading of the application is motion for leave to file, and therefore we do not see any problem. But my lords, fundamentally, we respectfully say, as in paragraph 15 of the affidavit, there will be no prejudice to the respondent by the grant of this application, especially as they ultimately elected not to adduce evidence in support of their case. So, my lords, we have not had sight of whatever they filed anyway, because I believe the registrar may have been under some instruction, but the registrar did notify us when he was serving other processes that that particular process had been filed but not served. That was notified, and we have not sought to have that because we don't need it. Our legal arguments are not premised on what they have said. Our legal arguments are very clear. And your lordships may note that we call it a draft, my lords, for a very specific reason. Because it is not, as is clear on its face, it is not yet complete. It is very clear it is not complete. In fact, there are gaps in places where certain things are meant to be included. It's very clear. And so, my lords, we've indicated there's a draft, and we've indicated a potential time frame within which the lordships may be willing to grant us the indulgence of filing. And therefore, we respectfully seek the indulgence that we have asked for in our application to enable us to file our closing address. And my lords, may I finally say that when we stand here at the bar, we stand here as officers of the court. We stand here as officers of the court seeking to help the court advance the interests of justice. And in that regard, I believe that a closing address that presents to the court the case of the petitioner in its entirety is something that will be beneficial in the interest of justice.
Mr. Chikata, how do you reconcile this prayer that you are now making to the earlier statement which you made when you were on your feet, that you did not know that there were predetermined outcomes? I heard you clearly.
No, Mr.
Chikata,
we can play
Mr. Chikata, can you listen to me? When there is intervention from the bench, you have to listen. That is a practice we know from the bar. I heard you. I may not have heard clearly. But what I heard is what I'm asking. Now, how do you reconcile this with the earlier statement that you made, that you did not know that there were predetermined outcomes to the applications that you had filed? That was why you did not file your address.
Yes, my lords, what I
did you say that there were predetermined outcomes?
My lords, no, I did not say it in the terms that you have put it. What I said was that when we made our application for review, we expected that application to be successful. We did not know that there would be a certain outcome. And my lords, we can plead and listen to it, but my lords,
you use the word predetermined.
Yes, my lords, I use the word in the context
if you can explain.
Yes, my lords, I use the word in the context of stating that what the outcome of that was not known in advance by us. So it was not, in our minds, it was not a predetermined outcome. That's the point I was making. For us, it was not a predetermined outcome. That is the fact. And that is what I said. That is what I said, and I believe your Lordship has just indicated that that's how you understood what I said. And if your Lordship understood it differently, that's certainly not my intent. I stated clearly that for us, it was not a predetermined outcome. And so we could not have, on that basis, prepared a closing address without reference to the potential being called. We could not have done that. That's a clear indication. And my lords, I mean,
by court, we are of the opinion that the petitioner should be granted leave to file his closing address on or before the close of Tuesday, the 23rd of February 2021, in the interest of justice. Yes. Yeah.
We're grateful.
Yeah. Yes. The petition is adjourned to the 4th of March 2021 for judgment.
My lords, I was actually going to make a preliminary before your adjournment. Is it possible that I may be heard on? Because my lords, yeah, in terms of the filing of the addresses,
yes,
I was going to respectfully draw your lordship's attention to the fact that there had been an earlier indication that you would provide a time,
yes, for you
oral highlights of my lords. May I respectfully finish? That time has passed. I'm aware of that, but my lords, in the light of the new orders, I was going to respectfully ask that after we have filed our written address, an opportunity may be available for your lordships to seek any. My lords, in the petition of 2013, there was an opportunity provided which enabled certain important legal issues that had been raised in the written addresses to be addressed by the bench and the council on both sides. And my lord, I believe that even if it's, you know, for a half hour, as the timekeeper has been rigorously insisting, that enables, you know.
Mr. Gigata, we have indicated that we are adjourning for judgment. Now, if we, upon reading your closing addresses, think we want some clarifications, we may come to you. But otherwise, we have adjourned for judgment. Very well.
Order in court. Order, please. Lords, writ number J1/5/2021, Article 64 of the Constitution and Supreme Court Rules 1996 CI 16.
My lords, I take it that you are done with our matters. Very well.
As amended by.
There is a contempt proceedings which the court
as amended by CI 74 and CI 99. Amended presidential election petition. Presidential election held on 7 December 2020. John Dramani Mahama versus Electoral Commission of Ghana. Nana Adodankwa Akufo-Addo. Dr. Dominic Akrutinge Ayeni, contempt no. Lord, contempt no present.
Oh, please, yes. Are you represented?
Yes, my lord.
The council, may you respectfully announce yourself?
Frank Beecham appears for the contempt with Koko Bramlabi and David Beecham.
Yes. Mr. Ayene, sorry, Honorable Dr. Ayene, please, you have been summoned here by this court to show cause why he should not be committed for contempt. Yes, because on the 16th of February 2021, we made certain statements which were very, very scandalous of the court.
Sorry.
Yes, we've exercised restraint in invoking our jurisdiction to always be committing people for contempt for obvious reasons. The other time, I think you were here when I drew the attention of Mr. Frank Davis. I think so also, yes, Lawyer Pong, then Marietta, the former learned Attorney General. I drew the attention and they stopped. But then, from nowhere, you also jump in onto the free end. You made certain scandalous statements which the bench thought that it was least expected of somebody who held a very high office as the leader of the bar when the Attorney General was not present. The Bar Association is just an association, but the Attorney General is the head of the bar. Yes, in every common law jurisdiction. So that is one of the enviable positions at the bar. Yes, I know the lead counsel was a president of the bar, but Attorney General, somebody who has acted as Attorney General, is the head of the bar, not the Bar Association president. And we want you to tell us whether you did say those words. Then you proceed from there.
My Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis, and Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter this morning to the Registrar of the Supreme Court to bring it to Your Lordship's attention.
Yes, we have copies of the letter and we've circulated it. Yes, we are comfortable with the apology, but we want to make certain consequential of this. Yes, Mr. Beecham. Yes, you can be heard.
Yes, my Lord. With respect, our client has no excuse. Personally, as lead counsel for him, I was very disappointed at the article that I read last week and was deeply distressed when he called me last night. And I thought it was because I had made certain disparaging remarks expecting some action to stop this canker in the profession. It was to tell me that he had realized the error of his ways and pleaded for me to join him to render an unqualified apology to this court. He makes no excuses for that. He admits he is wrong and has been wrong. He deeply regrets the harm done to his profession, the disrespect shown to the court and to also to the country. I have his instructions to render his unqualified apology to every member of the Supreme Court and indeed the judiciary of Ghana and to the legal profession and people of Ghana that he is awfully sorry for what he has done. He is deeply remorseful and he deeply regrets what he's done. So, my Lord, our prayer is, yes, true justice has to be done, but we ask you to temper justice with mercy.
You are a former president of the Ghana Bar Association, is that right?
That is so, my Lord.
I have been worried for some time now, listening to people granting interviews to the media, and not any ordinary people or lawyers, but people who have occupied very high position in this country. And we have to decide where we want to go as a country. In my view, the only reason why Article 88 of the Constitution, or the only ministerial position which is provided for in the Constitution is that of the Attorney General, is that when you are appointed an Attorney General, you are appointed an Attorney General for the whole country. A party or a president may appoint you as Attorney General, but once appointed, you are the Attorney General for the whole country. And you are to ensure that every citizen of the country is given justice or has access to justice and fair trial. So when I hear former Attorney Generals and Deputy Attorney Generals mount or grant interview and make certain statements, aligning in no uncertain term to one political party, it's something that worries me. And as a former president of the bar, I think you have to open a debate in that area about the proper role of attorney generals or former attorney generals, having regard particularly to Article 88 of the Constitution 1992.
None with respect.
Two lawyers to support you. What we can do for your client is to let him go back and purge the contempt. Yes, he spoke to the whole world on television. Yes, he should tell the people that he's very, very sorry. What he did was wrong, and that is all. We are not going to find him, we are not going to give him a bond, but at least coming from somebody who has acted an attorney general, if we don't take any action, it is going to send dangerous signals elsewhere. That is all what we want to do for him. So if he does it today, the court will assemble on Thursday and just strike out this matter. That is all. We are not exacting any serious punitive would I say measures against him. All what we want to do is for your client who has confessed to whatever he did to he just go and apologize for the harm that he has caused to the profession and to the bench. This is our profession. Nobody can come from elsewhere to make it better. Yes, beyond the lawyers, nobody can come from elsewhere to make it better. Yes, we can make it. And it is a duty which has been imposed on us by our call. Yes, so please, let's all cooperate. At times you hear some comments by lawyers and you feel that they are killing the profession, because a time will come when nobody will come and sit here as a judge. Yes. We posted one judge to ECOWAS court as a high court judge. He's not the president. Whereas the other countries posted their Supreme Court judges there, a high court judge from Ghana was the president there. But this is a something. We have the Court of Appeal judge here. He sought the leave of the Chief Justice to take an outside appointment. He's the Chief Justice there. And no matter what we do, please, the profession first. Yes. The profession first, and we should endear ourselves to the respect and whatever it will take to bring the profession to its past glory. So we thank you very much for not dragging this matter and coming with an unqualified apology. So that is what the bench has decided. We don't want anything from the former Attorney General, the Deputy Attorney General, but all what we want is the retraction, yes, an apology, yes, through the same medium, and that will end the matter. If he does it, we'll come here on Thursday and have it struck out.
Yes. We are very grateful to you for this indulgence, and also taking the cue from the point made by my Lord Mugachi, whose views I share personally, on a personal basis. And I did indicate to you why I stepped in, because I was even more worried when he called me. I thought someone had accrued that I had made disparaging remarks about his comments, but that's the point. But the right to be done, Lord. And we are profoundly grateful for your indulgence, and promise you that even before we came here, we have started the process of showing remorse and regret. Most grateful, my lords.
I will say something soon because Mr. Dr. Aine is a friend and a brother to me. I know he is a member of parliament and therefore a politician. But he should know how to talk when he is addressing the press as a lawyer, and then how to talk when he is addressing the press as a politician. They are two different things, because I know when politicians mount the witness box, they say anything, they can say anything at all. Then at the end of the day, when they are recorded, they come to deny. I've been a politician before. I know how it is. So you should know how to talk as a politician and then how to talk as a lawyer. They are different things altogether. Besides, we've been insulted, judges are insulted by people who know nothing about the law, and sometimes who know nothing about the issue that is before the judge. And they talk and insult. If they are not lawyers, we don't care. Because if you don't want to be insulted, you cannot be a judge. But if you are a lawyer and who knows the law and who knows the procedure, and then you talk, in a manner, that does not speak well of you as a lawyer, it gives opportunity to non-lawyers to also talk or say worse things. So that's my advice to him as my brother.
We're grateful.
You know what he has done for them? I remember when we went to the country. Ask him. I called him, and he was prepared to go to the news file to explain what obtains at the various faculties and why people should pick and choose and put their wards and children there to study law, not any faculty without lectures and whatever. And yes, the bench approached you, and you did it for us for free. Yeah, so these are some of the things that we can all, do to help the profession. It's nothing more. Yes.
So we're really grateful, and thanks for.
And just one more thing from me, Mr. Dr. Aine, as a former Attorney General, I have sat with you on the Judicial Council before. The two of us have jojoed to even appoint justices of the Supreme Court. You know the challenge, the difficulties, what we went through to appoint justices of the Supreme Court for this country. So after serving the Republic in that light, it seemed proper for you to go and make those statements to give the impression that the justices make decisions based on certain things. That's why some of us are disappointed at that statement. But having rendered this apology, we know, as my brother Justice Apau said, sometimes out of some kind of excitement or so, you are forced to make certain statements. As we've said here, we all make mistakes. We are human beings, and once in a while we cross the line, we make mistakes. So I'm happy that at least you've realized that what you said was overboard and you are prepared to retract it. But going forward, let's remember that we have one country and we all have a responsibility to keep this country together, no matter the circumstances and the situation we are confronted with. Thank you.
Lord, we are grateful for the admonition. I promise you, this will not occur. I'm grateful.
Yeah, by court.
Yes, my Lord, with all due respect.
Yes.
My Lord, before this matter commenced, your Lordship mentioned my name. My Lord, with the greatest of respect, with all respect to this court, I just want it to be placed on record that I have not said anything to scandalize this court. I believe that...
I didn't say so. What I said was that when we started the proceedings, you were granting interviews, and we drew your attention to the new legal profession ethical rules. Yes. We drew your attention to it, and you were advised to stop, and you did.
My Lord, your Lordship, I no doubt dispute that.
Yeah.
But I think before the proceedings,
I never said you.
Something was said to that.
Oh.
Myself and.
Yeah. And
my Lord, if that is the position of the bench, I'm exceedingly grateful. I don't want my name to be associated with scandalizing this court. As a former president of the Great Accra Bar, the longest serving president of the Great Accra Bar.
And the most populous bar.
Yes, and the most populous bar, arguably. Justice Amigache is not looking at me. I was the Mugabe of the bar, and I remain so.
Yeah.
I'm grateful.
Yeah.
I'm grateful.
I thought you were the Nkoswahili.
Yes, Prof, you can call me that. That was conferred on me by the Sanzini Amisha as a Nkoswahili of the bar, so I still remain.
And we take this opportunity to also thank you for your end of year dinners for the bar. For the bar and the judges.
So far as that is concerned, Justice Apo can bear ample testimony.
So thank you.
With my eloquent service of blue label Scotch whiskey.
Thank you. Yeah, thank you. This is the order of the court. We accept the apology of learned counsel for the contempt law. We, however, order that the contempt law purges its contempt by retracting the scandalous statement on the very same medium before Thursday, the 25th of February 2021, when the court will reconvene. The contempt proceedings is thus adjourned to Thursday, the 25th February 2021 at 9:30 a.m. So, Mr. Bicham, so you will come here 9:30. If he renders the apology, you will come and completely vacate the order.
My Lord, just for some clarification.
Yes.
I don't believe we are expected to be here on Thursday. No, we just want to be, yes. Very well.
If you want to come and show solidarity, you are invited, you are at liberty to attend. So.
All rise.
Past 3 is the time. Welcome back from the Supreme Court, and we are live here on Ghana Television and also GBC News and on Unique 95.7 and all GBC networks across the country, and on Facebook, Ghana Broadcasting Corporation. The ruling has been given finally. The review for reopening the case has not been approved and dismissed, and part of the phrasing there says that it lacks merit, and so that's it. And finally, the court has given the 4th of March 2021, this was next week Thursday, for judgment.
Yeah, so we're still here in studio, and we've been joined by Dr. Ajiman Budu. He's been here all through the process, helping us understand the very details of this particular election 2020 petition hearing. He joins us once again. Good afternoon to you, Doc.
Good afternoon.
Right, it's been interesting in court. By way of telling us what's happened, can you just briefly take us through what's been happening after we went for that break?
All right, so the first thing that happened was that the court gave its ruling, and until we have the certified true copy of the ruling, we will not be able to delve into detail because we just had the Honorable Chief Justice read out the ruling. But from what I heard, the ruling was to the effect that the petitioner had failed, first and foremost, to indicate the nature of the subpoena and the type of evidence that was to be adduced. And so the application was dismissed as not being supported in that regard by any law and settled practice. The court went ahead to set out or suggest that they had set out the boundaries in their 16 February ruling, the boundaries that must be complied with if the court were to or was to exercise its discretion to allow a party to reopen its case. And so they proceeded to set out the 6 grounds of review, which the petitioner set out as occasioning a great miscarriage of justice, and proceeded to deal with them consecutively. So, for instance, the court disagreed in its ruling with counsel for the petitioner on the alleged fundamental errors that the petitioner was alleging the court had engaged in, and reiterated the fact that they were the highest court of Ghana, and their decisions are binding, their decisions of law are binding on all other courts in Ghana. And so they talked about also the interest of justice not being only the interest of one party, but in order to determine what is just regarding the duties of the parties in that particular suit. And so they set out the threshold once again that you need to meet when you have voluntarily closed your case, and then proceeded to deal with the issue of Section 26, the issue that had to do with the conclusive presumption that the petitioner was alleging that by virtue of statements or averments in the positions deposed to by the chairperson of the Electoral Commission, suggesting that the interrogatories or the questions contained in the application for interrogatories that the petitioner sought to serve.
No, just kind of hold on for us. We'll go for the press conferences from the two parties, and then we'll get back. So let's quickly move back to the forecourts of the Supreme Court for the press conference.
The country that we have. What the country that we There's a certain page I have marked. Okay. 28 since April. April 12th.
Please, are we all ready? Okay. Good afternoon, distinguished friends from the media. As always, we are grateful to you for the opportunity to address the nation and by extension the world on the course proceedings on the 2020 election petition, a matter which is of considerable public interest. Several things happened in court today. The first was that counsel for the petitioner moved an application for leave or an application for review of the court's decision on 16th February, which is the court's decision on our application for leave to reopen our case so that we could subpoena the chairperson of the Electoral Commission to testify. Now, for those who are not lawyers, an application for review is a right given to any party dissatisfied with a decision of the Supreme Court to apply to the court and invite the court to respectfully review or change its own decision. And Article 1331 of the 1992 Constitution and the decisions of the Supreme Court has made it clear that you can apply for review of the court's decision, and in fact the court will review that decision where there are exceptional circumstances such as fundamental errors of law committed by the court which have occasioned a miscarriage of justice. And so today's application for leave that counsel for the petitioner moved was to achieve just that, to demonstrate to the court that in its decision of 16 February, certain fundamental errors of law were made, and to invite the court to remedy or rectify those errors by reviewing its decision in the interest of justice. Now, the grounds that counsel for the petitioner relied on in moving this application was that, one, you would recall that when counsel was moving the application for leave for the court to allow us to reopen our case, he was asked in what capacity he was seeking to call the chairperson of the first respondent, and he answered by saying that the petitioner was going to call the chairperson of the first respondent, the EC, as an adverse witness. And so you would recall that in the court's decision, the court stated that in their opinion, it was wrong for counsel to have said that he will be calling the chairperson of the first respondent as an adverse witness because per the Black Law Dictionary, a witness can only be described as an adverse witness after the witness has entered the box. And if it is detected during the evidence in chief of that witness that he or she is giving evidence adverse or contrary to the case of the party examining him or her, then that witness becomes an adverse witness, and counsel can then apply to the court to treat the testimony of that witness as that of an adverse witness. That was the decision of the court. Now, ground one of today's application argued that that decision of the court was a clear fundamental error because it did not take into cognizance Section 72 of the Evidence Act. Section 72 of the Evidence Act is simple. It says that subject to the discretion of the courts in a civil action, a party or a person whose relationship to that party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination. And so if you are a party or you are a witness or any person and your interest in the case is substantially the same as a party in that case, then an adverse party can call you to give evidence. And so in our respectful submission that we made to the court through counsel for the petitioner, one does not have to enter the box before that person can be described as an adverse witness, and that Section 72 of the Evidence Act allows a party to call a person whose interest in the case is substantially the same as another party, in that case, as an adverse witness. And so for us, the court's decision for this reason was per incurium. Per incurium basically meaning that it was without recourse, or it did not apply this section. And for us, this is a very serious fundamental error, because as the court itself has held in several decisions, the court is the servant of the legislature and must apply the rules or the laws that the legislature, passes. Then secondly, counsel for the petitioner argued that the court committed another fundamental error of law when it stated in its ruling of 16th February that Section 26 of the Evidence Act is inapplicable. It wouldn't apply Section 26 because of Order 38, Rule 3E5. And just to break this down so that those watching can understand, counsel for the petitioner has argued, and we have explained or elaborated that point here on several occasions, that for us, Section 26 establishes the principle of estoppel. And that section basically says that if through your acts, statements, or omissions, you intentionally and deliberately makes another person to believe a thing to be true, then the truthfulness of that thing must be conclusively presumed against you. That person having relied on that representation from you. Which basically means that if per your actions you make me believe that you will do something, and I rely on that, the court should not allow you to reserve from that position. And we have explained that. We are saying that G. Mensah, through her depositions in at least 2 affidavits before the court, made it clear that she will be available for cross-examination to answer certain questions. And so she's bound by Section 26 under the rule of estoppel to change her position. And in that ruling, the court said, because of Order 38, Rule 3E5, we will not apply this. And we, today, counsel for the petitioner respectfully submitted that that was a fundamental error of law. Because number one, Order 38, Rule 3E5 has got nothing to do with the principle of estoppel and a witness or a person being, being held by the court as bound by a previous representation. That order has to do with a party having the rights not to call a witness who has already put in a witness statement. The purpose for us relying on Section 26 had nothing to do with a party. It had to do with G. Mensah as a person. And so for us, that was completely irrelevant. And counsel for the petitioner further argued that even if there was any relationship between Order 38, Rule 3E5 and Section 26, Order 38, Rule 3E5 could not be interpreted or construed as having precedence over Section 26, because in the hierarchy of laws, a constitutional instrument is subservient to an act of parliament, and Section 26 is provided for in the Evidence Act, which is an act of parliament and which is superior to Order 38, Rule 3E5, which is a subsidiary, provision in made by the Rules of Court Committee. Again, counsel argued that the court did not take cognizance, or the court did not apply Order 38, Rule 10 of CI 47, which counsel indicated to the court that he was going to apply should leave be granted for the petitioner to reopen his case. He said, I will follow this rule, Order 38, Rule 10, which is basically the rule or the process for the issuance of a writ of subpoena. And that the court's decision did not make any reference, not only to Section 72 of the Evidence Act, but did not also make any reference to Order 38, Rule 10, which we had indicated that we were going to rely on to subpoena Mrs. G. Mensah. Then he spoke about Article 19.3 and Article 296 of the 1992 Constitution, and Article 19.13, has to do with an adjudicating body acting independently, impartially, and ensuring that a case brought before that body, is conducted in line, fairly, in line with a fair hearing. And in our opinion, counsel for the petitioner submitted that if you look at the way the court has failed or refused to apply certain statutes, and the court appears to be shielding, in fact that is in his statement of case, shielding the EC chairperson from accountability or testifying, it is not fair, and it violates the petitioner's right to a fair hearing as stipulated under Article 19, Clause 13 of the 1992 Constitution and Article 296. And the question we always ask, which we would like to reiterate today, is that why must we go through all these tedious processes just to get a public officer who we pay as citizens of this country, a public officer who has discharged a certain constitutional duty by conducting elections and declaring the outcome of same? We are talking about G. Mensah, the returning officer for the 2020 presidential election. Why must we go through all these hassles, all these troubles to get this woman to just give account of her stewardship, how she did her job, and how certain things happened, so that the courts can know the truth in these matters and do justice? If she has nothing to hide, if she has done nothing wrong, why must we go through all these tedious processes? Now, there were questions about, but you close your case voluntarily. Yes, we close our case based on the representations of the EC chairperson that she was going to be available for cross-examination. And at the time we were closing our case, we could not have subpoenaed her to testify because she had filed a witness statement and several affidavits which had made it clear that she was going to testify for the first respondent. And so the law and the rules of this court would not have allowed us to even subpoena her at the time. So this issue of, you close your case voluntarily, you cannot, no. The last time, the president of the bench stated clearly that it is a settled principle of law that a party can apply for leave to reopen his or her case after he has closed his case. And that is what we have done, and we believe that we have demonstrated that the circumstances or the conditions which are important for such, for leave to be granted in such circumstances have been demonstrated. The court dismissed this application and said basically that we failed to show the reasons why we were seeking to subpoena Madam G. Mensah. Now, because of time, I will not go through our statement of case and all that, but you can check paragraph 28 and paragraph 42, and you can see for yourself that counsel for the petitioner and the petitioner explained clearly why we need G. Mensah to enter the box. We explained that she is a returning officer who made a declaration of 9th December. It is she who claims to have made errors. It is her outfit which purportedly sought to rectify that error through unlawful means. It is this same returning officer and her office who have sought to churn out conflicting and inconsistent figures. And that it was important, among other things that we say, it was important that she be made to enter the box, cross-examined, so that the truth in these claims could be unearthed for Ghanaians and the court to appreciate all these things. So we disagree with the court that we did not show why we are seeking to subpoena G. Mensah and the usefulness of her testimony to the determination of the issues before the court. We believe that the evidence before the court shows that we did that. Again, the court, in interpreting Section 26, commenting on that, said that, there are certain conditions when it comes to promissory estoppel. Now, it's instructive to note that counsel for the second respondent, Lawyer Kutampa, had suggested that G. Mensah didn't even make any representation to us that we could have relied on. And that what G. Mensah did was basically to state the position of the law that she will be available for cross-examination. That was not a representation, was not an undertaking. Those were his words. Now, the court in this ruling says that it is a representation, but same cannot be said to be unambiguous. In other words, it is ambiguous. We have read those depositions over and over again. Those depositions are undertakings. Per Section 26, G. Mensah is bound by same, And there is no ambiguity in those depositions. She says clearly that the petitioner will not suffer any prejudice or injury because the petitioner can solicit the answers he is seeking through interrogatories during cross-examination. And we believe she meant what she said. Before I conclude, again, the court spoke about Section 72 of the Evidence Act that counsel argued on in this case. And the court said that there is no inconsistency between the Black Law Dictionary decoded and Section 72. Yet the court still stands by its definition of who an adverse witness is, that a person must enter the witness box before he or she can be described as an adverse witness. Clearly, you can all download the Evidence Act 1975 and read Section 72 for yourself. It says that, among other things, a person whose relationship to a party makes his interest substantially the same as a party may be called. So you can be called to enter the box as an adverse witness. You need not be in the box before, on the basis of your adverse testimony, you are described as an adverse witness. And so there too we disagree with the court. But ladies and gentlemen, a lot happened today. We do want to bore you with all the details. The bottom line is that the petitioner is worried that the courts, in deciding these applications, are not applying statutes that have been passed by our parliament and statutes that the court has been applying in other cases. And we think that the petitioner is being denied a fair hearing, and it is important that these issues be pursued to their logical conclusion. Now, why are we doing all these things? We are doing these things because of the constitution that all of us as Ghanaians have agreed to be bound by. Article 63.3 of that constitution says that no person should be made a president until and unless he attains more than 50% of the total valid votes in any presidential election. And it is clear from Jean Mensah's own declarations and the figures contained therein that candidate Akufo-Addo did not get more than 50%. We've done the mathematics here over and over again, and you can do the mathematics yourself. He did not cross. And so the petitioner, John Dramani Mahama, His Excellency, is doing this for and on behalf of all of us, and he's doing this in defense of the Constitution. And so we must all be interested in this case. Let me appreciate those who have been encouraging us and cheering us on. We really appreciate your encouragement. And we are assuring you that we are not giving up, we are not giving in. We are fighting this matter in the interest of justice and for God and country to its logical conclusion. So that tomorrow, an EC chairperson or an EC will not arrogate to themselves the power to choose leaders who have not met the constitutional threshold that we have all agreed to work with. We don't want that bad precedent to be set. The will of the people must always hold sway over the will of a select few. And for those who are crestfallen, those who are discouraged, and sometimes call us worried, disturbed, why don't you withdraw this matter? Why you shouldn't even go to court? We want to tell them that we understand and appreciate your frustrations. We understand and appreciate that. And we are telling you, don't give up. We are not doing this for nothing. We know what we are doing. And we are doing this because of the love we have for Ghana, particularly that of the petitioner. And so let us all be patient with the legal team as we go through the process. We are not abusing the court processes like some are suggesting, and we have not defied the orders of the courts. Everybody knows that any party dissatisfied with the decision of the court is entitled to a review. And so we are just using processes provided for under the laws of this country that we have all agreed to be bound by. And let me just say finally, like I said last week, that no matter how this case will go, no matter how the decision will go, because we are all discerning, because we all love the truth, because we are all following this case keenly, the truth will become clear to all of us and we will all see the truth. And don't always think that when people come to courts and the applications are dismissed, it means they are wrong. No. What it means is that the court is right for the time being, and it is what the court has said that will prevail. Like now we disagree with the court, but whether we like it or not, what the court has said is the law, and that is what will prevail. But posterity will be the judge of us all. Just like it happened in the case of Ray Akutu. when the Supreme Court then unanimously dismissed the case brought before it by Joseph Dankwa, J.B. Dankwa, with regards to the unconstitutionality of the Preventive Detention Act. Today, even though the court held in that case unanimously that the presidential oath was akin to the coronation oath of the Queen of England and didn't constitute a Bill of Rights and all that, today, what is celebrated is not the court decision. In fact, that is the most unpopular decision in the history of this country, even though it was a unanimous decision. What is celebrated are the submissions of J.B. Dankwa. And we believe that posterity will judge us very well. Will judge us very well. Now, we are hoping, based on the indications that the court has given, that they may find it necessary for counsel to be given the opportunity to make some submissions, oral submissions, on the written submissions they have been asked to file. There's not been any clear indication to that effect that will be done, but the court says that if it finds it necessary, the court will do so. We think that looking at the considerable public interest in this matter, it will be important for that to be done. But if the court, in its wisdom, decides that they are not going to allow counsel to make any oral submissions, we will respect that, and we will be engaging you in the media, and we'll be sharing with you the content of counsel for the petitioner's written submissions. And so that's where we'll end it. If you have any questions, you can ask. Of course, in 2013 it was done, so we are hoping that that precedent, which is a very good precedent, will be repeated in this case.
Thank you. Two quick questions. The ordinary bench and the application to reopen, a 7-member panel dismissed the application. We have an enhanced panel, 9-member panel, equally dismissed the application. Obviously, from what you have said, you are dissatisfied with the decision, but you have to file your address anyways, and you would have to do that, close the case, file your closing address without the benefit of the testimony and cross-examination of the EC chairperson. Question number one, are you disappointed? Question number two, is the NDC going to be seeking another opportunity to hold her accountable, as has been the talk all throughout?
Okay. So the first one, are we disappointed? Yes, we are disappointed. We are disappointed that, in our opinion, the petitioner is not being given a fair hearing. We are dissatisfied that, in our opinion, it appears that the EC chairperson is being shielded. We are dissatisfied that, in our opinion, and as articulated by counsel for the petitioner, known principles of law and statutes that our parliament has passed, that the court has previously applied, are not being applied to this case. So, in our opinion, we are not being treated fairly, and we are disappointed. But the decision of the court is what prevails. And to answer your second question, are we going to explore other opportunities or avenues to hold her accountable? Emphatically, yes. We will explore. We mean it when we say we will explore all options and fight this matter to its logical conclusion. Any other question? Okay. So, Baba will do this.
Yo, anyone, I say, ne court by no, in Sembe, you know, and a see or court her. Yedi kind, I say, a system for a tree, court to see Jinaebi. Jinae see in his own my own who quite me, asem. Send a bay betting from my major mensa. Now about a becan and moons and watch and ye see or abatrunum. And nay, some by say, courtroom sign Henry Jina Enebium. A sign say, Yea, you moody and some major mensa, one man who was a me, or no. Anna or declare election, or no, and or my figures different, or no, and or treason and a covered with Winia, yea, Yensus Money and Kunda Bumuno, Nana covered the way 50% plus one way. And it's a baba cansam, Naso or no, ma am a cabidia, not just as some kind, not a refail. Ye Kainu Moon Sambiara, and so court no any anyading, court no any and say. Ono de ofose ma meji mensa ba enye saa semi ene asem wesi o court na yen ye yegusu agina bebi agina se court na kasa de na ne court no so beka ɛna ɛyɛ mmara bɛno nso nkyerɛ sɛ sɛ wo ne court nga adwene a wontimi nka wasɛm ɛyɛ me nua kasa no ɔma decision bi a ɛmmerɛ bi court na si agyinaeɛ a court nipa na wɔhɔ nyinaa kaa sɛ nea ɔma ka no na yɛ nokorɛ na nsia ɛbɛɛkyire no na asɛm no asesa enti yɛn yɛgyidie mu deɛ yɛnim sɛ asɛm no a yɛkɔ no neɛ court ka yei no waka deɛ na yɛn nso yɛne ɔmo nyɛ adwene yɛbɛsɛ yɛhyɛ ghanafoɔ nyinaa bɔ sɛ neɛ yɛyɛ no ɛnyɛ sɛ yɛyɛ no kwaakwa yɛyɛ ne sɛ yɛnim neɛ ɛyɛ John Dramani Mahama wɔto no ho asi hɔ sɛ ɔbɛboa mu obiara court nsɛm a waka no obi ate aseɛ wetu no ho gyina hɔ sɛ nokorɛ wɔ saa asɛm no mu ɛwɔ sɛ pie ɛnti sɛ obi gyina hɔ na ɔka sɛ bio adentina mo kɔ so yɛ adentina mo nya ne yɛpɛ sɛ obi ate aseɛ ne sɛ John Dramani Mahama ogusu gyina bebi ogyina ne yɛbɛyɛ biara kwan bi foforɔ bia wɔ hɔ na ɔse yɛfa so ma maame no ɔbɛka n'anum nsɛm ma nokorɛ no dɛ adi ma Ghanafoɔ tie a inshallah yɛde wɔn bɛba salamu alaikum jamaa yau kuma mun zo court inda muka zo court abinda muka gani yau shine matan da ta saya aka yi wanga takara matan muna so ta zo ta shiga cikin takaran ta shiga cikin adaka ta yi magana mun yi court wai bai ra'ayi da mu ba amma abinda muke so jama'a su gane ba wai ka zo court na ka yadda maganan ka ya kare ba akwai hanyoyi da yawan da za mu bi ba kuma abin da za mu bari ba za mu ci gaba inda za mu bi matan ta shigo ta bari jama'a su gan gaskiya a me ya faru domin ita ta zo ta yi declaration nan ita ta sai aka yi takaran abin da aka yi duka ita ta yi to don me za zo a yi magana a ce babar ta shiga a daka don me za zo a kawo magana ta ce ba yarda yau mun zo court wai bai yarda da mu ba amma abin da muke so mu gane in kotu bai yarda da mu wannan bai gwada kuma magana ta kare ba za mu ci gaba inda za mu bi magana ta kwanta matan ta zo ta faɗi gaskiya ko yau ne ko gobe ne ko zuwa gaba ne za mu bi mu bari ta zo ta yi gaskiya. Assalamu alaikum.
Please, Dr. Ayine will address you briefly. So.
Madam, we'll stand by.
Let's all stand by him.
He's coming.
That's okay, I'll stand.
Okay. Thank you.
I'll stand beside you. I'll stand beside you.
Okay, all right. Yeah.
Let's
okay. All right. Good evening, ladies and gentlemen of the press. I am here this evening in respect of the remarks that are made to you on the 16th of February after court proceedings. Those remarks were widely publicized by the media, and both mainstream and social media carried them and they went viral. I have looked at what I said that day, and I have come to the conclusion that I went overboard, I crossed the line with respect to the remarks that are made in terms of attributing impropriety to the Supreme Court of the Republic of Ghana. And I just wanted to let you know that this morning I delivered a letter to His Lordship, the Chief Justice, offering an unqualified apology to the court. Now that letter has been filed and the Chief Justice of the Republic has referred to it, I want to take the opportunity to read the content of that letter to you, and thereafter I will apologize and retract my words. Now, the letter reads, My Lord Chief Justice, summons to show cause unqualified apology to the Supreme Court. On the 16th day of February 2021, I addressed a press call at the premises of the Supreme Court in respect of a ruling that the court had rendered on that day. I did so in my capacity as a member of the legal team of the petitioner, with instructions to brief the press on matters of concern to the petitioner after court proceedings. In carrying out my instructions on previous occasions, I had always made certain that I explain the day's proceedings to the understanding of the press corps and of fellow citizens with civility, and without seeking to attribute acts of impropriety to the Supreme Court or the respondents. On the said day, I thought I had maintained that approach to the press briefing, but on hindsight, I actually crossed the line in suggesting that the court had a predetermined agenda, among others, to rule against the petitioner. My attention was drawn to this fact immediately after the press briefing by Frank Davis, Esquire, to whom I am grateful. It was not my intention to scandalize the court or to bring it into disrepute. In the circumstances, I wish to apologize unreservedly to the court. Yours sincerely, Dr. Dominic Akuruting Ayine, signed. And for those of you, I'm sure Mr. Frank Davis is not a stranger to the press. He's standing here to my right. I remember on the 16th of February when I finished addressing the press, he walked up to me and reminded me that the phrase that I had used, that there was a predetermined agenda, had crossed the line. And that is when I started thinking about whether or not I had crossed the line. And I agree absolutely with Mr. Frank Davis and those of you who think that I crossed the line on that day. I wish to unreservedly apologize to the court, that is the Supreme Court of the Republic of Ghana, as well as the justices in particular who sat on that day. There was no intention on my part to impugn their integrity. I was just expressing a sentiment with respect to the ruling of that day. And I want to render an unqualified apology and to retract the words that I used on that day in their entirety.
Unreservedly.
Unreservedly, I will not in any way want to disparage the Supreme Court of the Republic of Ghana. You can see I'm lost for words because I don't want to be, when you want to take a pegative, I was told that I should peg myself of the contempt. So you take the pegative so that you don't complicate the constipation. So I'm being very careful that the pegative I'm taking this afternoon will not complicate the constipation. And so I wish to thank the press for the opportunity to address you, because His Lordship the Chief Justice, in making the order, said I should use the same medium that I used in conveying the words that are the subject matter of the contempt proceedings. And so thank you very much, ladies and gentlemen of the press. I am hoping that my apology and retraction will be accepted by their lordships, and the matter will come to an end. Now, in respect of this matter, I plead with the press that I won't take any questions and provide any explanations. God bless you and God bless our homeland, Ghana.
Thank you very much.
Thank you.
Colleagues, good afternoon. We'll make it pretty snappy because we can tell that you have a big story today, bigger than all that has happened in court. So we'll make it pretty snappy. I think you have followed for the several hours of today the legal arguments that were made by counsel for the petitioner and then responded to by counsel for first respondent, counsel for second respondent. I think at the end of the matter, I want to draw your attention to the words of the Supreme Court speaking through His Lordship the Chief Justice in ruling. And I want to focus on that because lawyers express their opinions on the law, what they think the law means, what they think a proper construction of the law ought to mean. And I think today you are noticing that our friends on the other side now keep using the phrase that in our opinion, in our opinion, in our opinion. Initially, the argument was as though it was fact. But you notice that the point is being made that people express opinions, the court determines in the end. The court has said that the legal arguments, the provisions of some of the acts and the CI and some of the authorities that the petitioner's legal team tried to invoke, together with the principles of equity, and if you just listen to the court, it says that the positions that they were expressing are not supported by the law or the principles of equity. So even a reiteration of it before the press and a re-explanation does not change the fact that the law does not support the position that they've been expressing. And so we will not go into a reiteration of all the legal arguments that we made. I think this is about the third time that the court has dealt with this type of issue and has come to a certain conclusion on it. The court also says that they did not satisfy even the minimum threshold required to sustain an application of this nature. You know, sometimes when we make this point, it appears as though we ourselves are saying it. We are not the ones saying it. The court, I think this is the third time that the court has made the argument that the law does not support their position. They have not met the legal threshold. So we are not the ones saying that what they are saying does not align with the law. For someone to say we are disrespecting our seniors, etc. The court, the Supreme Court of the Republic of Ghana, is the one that is making the point that they have not satisfied even the minimum threshold. So we won't bore you with too much detail. The court has decided that on the 4th of March, judgment should be delivered in this matter. This is after the petitioner who came to court, among other things, arguing that nobody won this election, has called 3 witnesses, and has now, I think in the last 2 or 3 applications, been praying the court to literally force the EC chair into the box so that he can reopen his case and advance something else which he hasn't told the court, something else that can help make a better case for him. The court has decided that despite its earlier warning that if its processes are not complied with, it can strike out the matter, it will still accommodate them so that they can file their written addresses. I think this is clear evidence that nobody's being denied a fair trial here. The court has bent itself backwards and is accommodating the interest of all parties. So we look forward to the 4th of March for judgment. If it is the view of the court that they want to invite our lawyers, viva voce, to address some issues, they are more than prepared so to do. But Ghanaians have followed the journey that has gone on so far in the courts, where the petitioner was being looked to adduce the evidence. I heard our colleagues here saying that the mathematics is clear, but you have been here covering for all the days that we have been here. And I'm not sure that to you, you saw mathematics that yielded results other than 47% for the petitioner, Mr. John Dramani Mahama, and 51.2 for the second respondent, Nana Addo Dankwa Akufo-Addo. That was the mathematics that you saw Mr. Johnson Asiedun Ketia arrive at. That was the arithmetic that he arrived at, the answer that he arrived at when he did the various computations. Today you are hearing them telling you that the mathematics is clear, nobody crossed the 49%. But in the wells of the Supreme Court, before the justices, and I'm not sure you have seen them prove that. But in any case, we'll come back on the 4th, and then we'll stand by for judgment. So we'll keep it simple. We'll take your questions, and when I'm done, my colleague Nana B will do a quick Twi translation, and then Faisal will do a quick Hausa translation for us. We're going to take your questions.
Sami Jenfi stated that after this proceedings, if unfortunately the ruling goes against them, they're going to use any other institutional measures to still bring out the fact that they need from the EC chair. I want to ask, are you also ready to counter all the...
So for those who didn't hear the question, his question is the admission by the petitioners team now that they are willing to explore other avenues for the so-called accountability and truth that they talk about. First of all, let us reiterate that the truth is what has been laid before the court. The truth is what has been gazetted. That Nana Addo Dankwa Akufo-Addo, when you add the 38,000 plus polling stations, or you add the 275 constituencies, or you add the 16 regions, the truth is that Nana Addo Dankwa Akufo-Addo crossed with over 500,000 votes as a margin. It is the petitioner who seeks to challenge this truth, but has not brought his truth to court. Whatever counter evidence that he may provide to cause even the chair of the first respondent to get into the box, I'm not sure you have seen it here. But today they are admitting before you that they are willing to explore other avenues of accountability. Remember, about 2 weeks ago, we've been arguing before you that if you want accountability, generally, you can come to Parliament. The parliamentary committees of inquiry that can look into whatever matter you bring. And there's a 137 plus 1 Parliament. You can come to Parliament. You can come under the Right to Information Act, asking for some particular information. If it's judicial review that you want, that you think that the EC has not done something specific and the courts must bring its power to bear on it, the high courts are there for judicial review. So it is interesting that at the end of the case, when we are all wondering where the evidence that they were supposed to provide to back their case is, they are now opening up to you that they are willing to consider other platforms of accountability. We'll see which ones they choose, what case they make, and if there's any adverse arguments that need to be made there, we'll respond accordingly. Are there any other questions? Like I said, we know the big story that you have today, so we won't bother you with too much talk. Nanabi?
Yes. Abusiafo ene omana de hye yebeda mose senia minia kwadwo ponkroma abo ne tofa no saa na menso mikura no epo be enum nia edikan mobekaya na ano ana kwadubofo de tudwa se enka omasem ananka omatumu epono na omabo mu nkro nyina wie na omon nsem ni nyina na omose omaka amanasa omadansefoɔ enso asa ekowie akire no omose awose yɛtwe maame Jane Mensa ebegyina adaka mu ansa na omasem no asipi na asita anunti omope ekwan afri court ho court mo omokwan no mumie omasem nani no mu bi omasem nani nso a Omasade at court anim se court enhye maame Jane Mensa na ombegyina adaka na yentoto na no obekaya eno court empanimfo nso yinyina omadwen ekọ benkrom ema omoka se dabi enya ade ombema kwan amakwadubofo e petitioners no omabie omasem nani eno achi ena asem ebeto odwane se omosade adesrede sa beto eye Supreme Court anim se asamo na no mo kan se nkomo makwan emomu mbio masem nani no omo sere omo nsan sacha omadwene sanse emra bi ho no a omo amfa anya adwuma ene court akyerɛkyerɛm se ansana obeba Supreme Court se omo nsacha omadwene no enya kwa ena enya se oma oniema so anu abase yen sacha yasemani awose wo kyerɛ sɛ na adeɛ poten adeɛ sonko adeɛ nwanwaso bi wɔ hɔ no a onsanka ebra na yedi asɛm no na saa adeɛ nwanwaso no ama tentene ɛne pepepe yo akadwam ɛno kwadubɔfo na ntimi ankyerɛ na yɛ naano nkɔmɔbɔ na ɔmo kan no ɛno a na ɔmo saka dada no a asɛm fufuro bia eni hɔ eti court ɛsa akɔ ɔbɛkae ɛnɛ empanifo mienu sa beka ho mo ye nkono empanifo nkono nyina se asem a mo de bae no eni nyina so emramu ye nhu ye enu ntino ye ntimi ema mo kwan ma mo nsam bie mu asem nani na emom nyame ya adom a ya hye busumi a eba be wurami eda etoso 9 4th March ye de yatemu eba entino obibia nko na abeka nso a ade ba ko na kodubofo ne kapa na medi twato ene se court betie na court tie omuye na omu nsam omu wonyina no ombetimi aka
niemramu ye no fair trial abusuam bekaya ye share asem ne yasi court atia asem ne pa ebra omo ye mfomso kra omo kratam court mo kwan mo kosiesie de bae aye ensemfo anom so beso mo de pimpim easy ye mo kwan ye tie omo applications ahodo omo de aba beto court anim court tie omo se okinkanya applications a omo de aba beto court anim eye ensun ni nyina court no aboagu sanse omasem no eni nyinaso etinyame ya adomo a yesai be hia ewo ha sei busumi a ebewuramu eda etoso 9 na asem a ya na metatie eni se yenuanu mandisifo omunya rehemu sanse asemi de ekoye mesre so muntimi omadeso a momo mfa nhye omukahire enano pay me kaise mitie openi baako alaji nu safuseni ndc ni mapa oso no kwa wapaba sanse asem no ensuo bia enyinam tebusuanfo medam ase na ansa na menua feza de hausa de no bebrem no mese ne mpanifo abekan ye ho ene ye nhye bia ma agise 4th March nti mo fama so mfemme ye chairman ye pania odi anim chairman makmenu ene okan ye ho aha aya ono ana sa ye star witness on ejine mu ma omampani na adodankwa ekufuado lawyer Joy Sopoku Boateng nso ekan ye ho ewo ha sei ana Hajia Fatimatu Abubakar Esquire oye lawyer ni mapa ansana mia minua kwadwo Ponkruma minister designate information okodada ana ebiemu nso na adwoa adobia Asante Kati Mrs. enso ekan ye ho ha say lawyer ana Evans Nimakon director in charge of elections and research ye penny Bakon director of communications on say lawyer Nimapa osaka kasama for ho lawyer ya oboaben asamwa enso ekan ye ho ha ebiem Patriot Faisal enso lawyer Nimapa no so kan ye ho lawyer Lenin ekan ye ho ya lawyer for nkuma omo so boa research enso kan ye ho ha lawyer K Amoa enso ejina chire ho ansana niamate enso ewo yenchen wa ha ebiem the president's lawyer lawyer Ko Esuman and lawyer Hajia Hamida Nuhu omunya kan ho ha lawyer Akutampao lawyer Frank Davis lawyer Shila Menkampremo lawyer Kweku Esrifi lawyer Yaw Opon lawyer Yaw Ado lawyer Victoria Bath lawyer Ochiri Ejekum lawyer Dr. Ernest Owusu Dapa and your head of technical team the fearsome and the intelligent Joe Anoche Nyamishramo Patriot Rabbi Janefa House and the bomb
to yawa ina na fara da gaisuwa mai kanshi assalamu alaikum wa rahmatullahi ta'ala wa barakatuh yau da muka zo court abin da ya hafku ne lawyers for John Dramani Mahama suka zo da abasu anya an so su da case to ina kai ku baya kadan bayan da muka jefa kuriya December 7th the electoral commissioner ta fito ta bayyana results shi ya NDC suka zo suka ce an sata elections da muka yin nan sai suka ce kama su suka ci tuna waransu kaman fita otukuno sun fito har sun ba da figures da percentage da ke gwadawa kamar sun ci elections John Dramani Muhammad da kanshi shi ma ya fito ya ce election da aka yi ya ci Sami Jefi kuma ya fito har shi ya declare John Dramani Mahama kamar shi ne president elect da general secretary su Asedu Ketiya kuma shi ma ya fito ya ce kamar elections da aka yi su suka ci amma da suka zo court she suka sake bakin su suka ce ba su ci ba amma election da aka yi nan ba wanda ya samu more than 50% of the valid vote bi mana in aka raba vote da aka yi in aka raba cikin biyu ba wanda ya samu more than 50% isa nda bai fi a declare president Nana Addo Dankwa Akufo-Addo president ba da suka so suka file wannan petition she haki ya zo kansu domin in kai ka ja wani ka zo court kai allegation kan me shi ya fi ka kawo hujjanka da shaidanka da ke gwada kamar allegation da kai nan gaskiya ne to shi the court zai duba ya rule ibaka amma da suka zo suka kawo shaida guda uku witnesses uku a shaidu ketiya Dr. Michael Pesa White da Rojo Metodunu da suka zo maganar da suka yi da suka shiga cikin adakan bai gwarawa kamar allegation da suka yi na akwai hujja ciki to shi lawyer su ya tashi ya ce ma court kamar shi kesin ya kare kesin shi shaka tambaye shi ka kare wai na kare kesi na aka ce in ya kadan ni court ya ba da anya kamar EC da team president Akufo-Addo mun bude kesin mu she muka ce in ka duba evidence da suka kawo hujjan da suka kawo bai gwadawa kamar sun justify allegations su isa inda aka nan ne mu dai ba mu kawo mu namu to shi lawyer kuma ce bai yarda inda aka nan ne yana neman a sa ma EC ce igiya wuya an so a jawo ta a kawo ta a cikin adakan to shi court ya ce bai yarda shine yau suka file for review yau kuma court ya gwada kamar a'a ba wannan hanya to wuri muka kai yau court kuma ya bada date 4th March in Allah kai mu da mu zo a bada final judgment isa in Allah kai mu on the 4th of March mu zo danga an so mu zo mu ji final judgment. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
Those were the two press conferences, and of course we also did witness that apology rendered by Dr. Dominica Wijayini. But let me quickly remind you what happened in court today. First of all, in court today there was the hearing of the application by the petitioner for a review of the court's decision which was taken on the 16th of February. That decision which had to do with the petitioner applying to be allowed to reopen his case. Of course, the decision of the court was that the petitioner, that application was dismissed by the court. Then the petitioner's lawyers then appealed to the court to review that decision, which is what the court considered today. Of course, lead counsel for the petitioner, Mr. Chachuchikata, advanced his arguments drawing from very many legal authorities to back his appeal for that review. As was expected, lawyers for the first and second respondents, Mr. Justin Amenuvo and Mr. Akotampao, respectively, also objected to that application, also citing from several legal authorities and backing their claim as to why it would not be proper for the court to grant that application. The court went on recess for more than an hour and a half, and when the court returned, the decision was that the application had been dismissed. Following that, we also did see that the petitioner had made an application to the court to also put a stay on the proceedings. The petitioner then withdrew that application, and then the court announced that on the 4th of March is when it has slated for final judgment. However, after that, the court then called Dr. Dominica Wijayini, who was deemed to have made some contemptuous statements, and he did apologize in court, and the court then instructed him to use the same platform on which the contemptuous statements were made to retract and purge himself of that contempt. Indeed, during the press conferences, which usually is addressed by spokespersons of the legal teams, Dr. Wijayini then came, and that was the same platform he used to make those statements against the court, and retracted unconditionally and apologized unconditionally as well to the court. The court has told him to return on Thursday for the whole matter
to be struck out after he had rendered this apology. Basically, that's what has happened in court today. Final judgment, the court has indicated, will come off on the 4th of March 2021. Have a very good day. My name is Abdulhai Momi.